Yes. Will should be allowing the mentioning of SAT matters, but
No, today please don't mention.
next.
No, all SAT matters I will not allow. It will be considering the urgency.
Yes.
Sorry.
After your lordship delivers the judge.
Lordship, may I be permitted to mention one matter for non-prosecution?
Mention on Monday.
Monday.
Yes. Today is not the date for mentioning. Yes, call the list.
Item number 1. Item number 1, my lord, I am led by Mr. Partho for the petition.
Item number 1, my lord, I am appealing for the for respondent number 8, my lord, the son of the deceased. I'm sorry, my lord, on the last occasion, I was not present. My lord, kindly see order dated 16 December 2025.
You are appealing for whom?
My lord, the son of the deceased respondent, private respondent number 8, my lord.
Who is appearing for the petitioner?
My lord,
Who is appearing for the petitioner?
I am appearing for the
You are ready with the matter?
Mr. Partho Ghosh is appearing.
Yes,
Where is he?
he is
And
not.
on the last
come to-
occasion, I submitted that NTPC has two advantages insofar as the widow is concerned. One is the medical benefit, and the other is not the pension. That this is a pension
Yes,
of.
but now today are you in a position to address this court? Or you?
Lordship, there is a direction for filing the exception to their report, Lordship. I'm praying for 1 week or 2 week time, my lord, for filing the exception.
1 week or 2 weeks?
My lord, 1 week
Already
time.
order was passed on 16 December 2025. Just a minute.
My lord, let a copy be served upon me
Please
because
wait.
I have
Please wait. Please
My
wait.
lord, my lord.
So the previous order. Now, NTPC defined contribution pension, whether that has been paid to the petitioner. It is required to be forwarded to the Life Insurance Corporation, and
It will be sent to the trust of NTPC Limited, which is comprising of certain grantees from the employee side and others from the employer side. But they will certify and then remit it to LIC. But we shall follow it up with the LIC authorities.
no, but NTPC was directed to transmit the amount payable to the petitioner under NTPC defined contribution pension to the Life Insurance Corporation.
That is already completed.
And there was a further direction that the said benefits shall be released in favor of the petitioner on compliance of formalities by 4 weeks.
But this will take some time because of this will be sent to corporate office. There the trust office is in the office of the corporate office. But the employees and the employers representative will hold a meeting, they will certify and remit it to LIC for onward transmission.
The meeting will
Of the
be in
trust.
presence of whom? Trust of LIC.
Trust. No, trust of NTPC.
NTPC.
That's not the employer alone, it's from the employee side representation as well.
So how much time
Number-
will it take further?
But we will process it up. Lordship may take it up on some other day. But yesterday, we have received the application form for the post-retirement medical benefit. Today or day after tomorrow. By tomorrow, we shall send it to the corporate office.
Milord, it's not about pension only. The amount of the money is more than, Milord, 3 crores. If your lordship kindly sees the page
The dues which
40
are
of the-
payable to the widow only, not on the other.
Not your dues. You are not entitled to get those benefits. I have already.
No, so far as
indicated-
pension, I'm not. So far as, kindly see, Milord, give me 2 minutes. Kindly see, Milord, page 40 of the writ petition. There, Milord, a tabulation sheet has been given by the petitioner before the London district delegate at Jalpaiguri while, Milord, getting the order of succession certificate. There, Milord, this is only the page 40 is, Milord, only the succession certificate. Judgment has not been annexed.
I am
with
not on
writ
this.
petition.
This court is not on this issue. It is a settled position that NTPC defined contributions pension is payable only to the wife, not to the.
Absolutely.
So therefore, court is
Right.
contemplating that how this benefit can be extended to the petitioner being the wife. It is not payable to you. What is payable? That is stated that. So far, other
The
benefits.
entire money, Milord, has been tabulated in page 40 and 41, Milord. It comes around
Gratuity, provident fund,
crores.
leave encashment.
Yes.
Now, Milord, yes, I'm not on that, Milord. Fraud has been perpetrated upon the London district delegate saying that this is diet, Milord, issueless. But I'm the only issue. This is also admitted and accepted by my
Other
lord.
benefits means provident fund and leave encashment
And gratuity.
and gratuity. These are to be divided amongst the petitioner
The heirs.
and the heirs.
The subsisting heirs.
Pension I'm not on. I'm not entitled to get the
Court
pension.
is considering payment of pension
But
under
that's it.
NTPC defined contribution pension scheme.
Absolutely.
Under the
Pension
relevant
I'm not.
scheme. Now, so
Pension
far
I'm
other
not there.
benefits, Mr. Mojumdar regarding
Paragraph 10 of my report.
provident fund gratuity and
Leave
leave
encashment,
encashment.
medical.
How you are to pay?
Now he is appearing.
Yes.
Not if your lordship directs, not we can distribute amongst them.
Who are they? Yes, only the petitioner and the
Petitioner and the son.
and the son are
Yes,
in
yes.
first wedlock.
That's what has been disclosed to us.
Yes,
So therefore,
Milord,
it will be proportionately distributed to the to both the heirs.
yes, for that, Milord, I need to bring some documents on record. Milord,
Why? What for? Court will direct the NTPC to release other benefits, defined benefits to the petitioner and the respondent number 6.
8.
Respondent number 8.
Unequal distribution, Milord.
Yes, yes.
So pension, I'm not entitled to get the. I'm not saying anything about the pension. Kindly see page 40 only. There, Milord, the tabulation sheet has been given. Here, Milord, the entire amount comes to around more than 3 crores.
Court is not quantifying the amount. See,
Yes.
what are the admissible benefits that are to be released in favor of the petitioner and respondent number 8?
Yes, that's it.
So other benefits are as indicated in paragraph 10
10.
of your report. Leave encashment, NTPC death relief scheme, group insurance, RRP, NTPC self-contribution superannuation pension. Self-contributory superannuation pension is payable to the petitioner only.
Yes.
NTPC defined contribution pension scheme. These are the two benefits. What are the benefits which are only payable to the
Not
petitioner?
what is solely what the writ petitioner is solely entitled to is NTPC post-retirement medical benefit scheme and defined contribution pension scheme.
What about NTPC self-contributory superannuation pension?
That is an asset of the deceased which has to be probably distributed amongst the heirs.
Let a copy of the report be given to my junior who is present in court, Mr. Souvik Raichaudhuri, because I have not seen the report yet. I request Mr. Mojumdar to hand over the copy of the report to Mr. Rai Chaudhuri because I need to see it. I again tender apology for being absent on the last vacation, my lord. And my lord kindly comes to page 40 of the writ petition, my lord. The tabulation sheet. This has to be
The matter
NTPC.
is heard in presence of the learned advocates representing the petitioner, respondent number 8 and NTPC Limited So, it appears that husband of the petitioner was an employee of NTPC Limited, and due to his death, benefits are payable to the petitioner being wife and respondent number 8 being son of the deceased employee. However, it has been pointed out by Mr. Mojumdar and senior advocate representing NTPC Limited that pension under NTPC defined contributions pension scheme and benefits under NTPC post-retirement medical scheme are payable only to the petitioner, not others. Stop. It is also, court is also apprised on behalf of NTPC Limited that steps are being taken for early disbursal of benefits under NTPC defined contribution pension scheme. Stop. Concerned authority of NTPC Limited is directed to release pension under NTPC defined contributions pension scheme by 4 weeks to the petitioner on compliance of necessary formalities. Stop.
But only one submission. Not this will be released by LIC, not by us. Not kindly directs us to take all necessary steps to process so that LIC can disburse it within 4 weeks. This will directly be remitted to the person concerned by LIC.
Is directed to take all necessary steps.
That is recorded in the last order also.
Release of pension under NTPC defined contribution for release of pension under NTPC defined contribution pension scheme, and same shall be released with cooperation of LIC by 4 weeks from the date of communication of this order. Stop. Next paragraph. Benefit under NTPC post-retirement medical scheme has already been sanctioned. And
we received the application yesterday. We will forward it to corporate office for the release.
Benefits under NTPC post-retirement medical scheme shall also be extended to the petitioner. It depends upon the necessity. Medical
no, there has to be a card issued. Once the card is issued for outdoor treatment and indoor treatment, there will be benefit.
When there is medical requirement.
Of course.
Benefits under NTPC post-retirement medical scheme shall also be extended to the petitioner as per requirement. Stop. Next paragraph. On hearing the learned advocates representing the parties, including the learned advocate representing respondent number 8 who appears online, it is found that other benefits, for example, namely provident fund, gratuity, leave encashment are to be released proportionately to the petitioner and respondent number 8. Stop. Hence, NTPC is directed to release other aforesaid benefits, or NTPC is directed to release those benefits as per paragraph 10 of the report, which was affirmed on behalf of NTPC on 11 December 2025 to the petitioner and respondent number 8 on compliance of formalities by compliance of formalities at an early date, but not later than 12 weeks from the date of communication of this order.
Yes.
Stop.
I'm grateful.
Next paragraph. Writ petition says disposed of urgent xerox certificate.
I'm extremely grateful, Milord.
There is a direction to file.
Yes.
There is a direction to
Already taken over.
file the affidavit, Your Lordship.
I'm appealing.
What affidavit?
Service to
Appealing.
number 8.
Why you are not? You have not filed. Are you taking chance that whether the matter can be adjourned?
No,
You should have filed it at the very beginning.
No, he has filed, Milord, regarding the service of notice upon my
That I
client, Milord, he has
understand.
directed to file further.
To file affidavit service filed on behalf of the petition is taken on record.
I'm grateful, Milord.
Item number 2.
देखिए ओके डाको तो सोमनाथ को
Item number 2.
To my lord, may I please, your lordship, I am for the petitioner. As per your lordship's direction, I have served copy of the last order and this is my affidavit of service.
But they, when it comes to this is the written instructions that I have received. But will kindly come to page 2.
Have you received the report of the Central Financial Government of Calcutta?
Yes, yes. That
already the first report which was issued by the Directorate Central Fingerprint Bureau National Crime Record. So what is the report? What tell me in one sentence that what is the report of Central?
that I'm under oral instructions that also favors the petitioner, but that is. But it has the report has been placed before the board as per the written instruction. But I am told that the
For delay payment.
but
For delay recording. Yes.
but
Order was passed on 17 December.
the report has come. I am told that the instruction says that it has been placed before the board. The 9th January we received it.
Now, report in terms of the order was already made available. So far, Directorate, Central Security from Delhi, thereafter order was passed on 17 December 2025. Central Forensic Laboratory Kolkata was directed to verify if it is verified in a positive way.
But 9th January, that was forwarded to me, and will kindly give me report, liberty to bring the report.
Give appointment to
The only, but I don't have the report with me, man. That is the only difficulty.
So far as my instruction is concerned, other candidate has issued the appointment, except petitioner.
That I have take instructions in regard to this, but the report has come, my lord.
There is no question.
But I'll instruct my the officers. I'll advise the concerned authority. But I'll communicate so that
Who directed the authority at New Delhi. Report was made available. Then it was pointed out that the Director Central Forensic Laboratory Kolkata is required to verify it. If it is verified, then why should not
I'll advise my clients to ensure that the necessary steps are taken as soon as possible.
on hearing the parties, it appears that Director Central Forensic Laboratory Kolkata, the Supreme Court, has made the report available to the concerned authorities relating to appointment of commissioners as constable senior under Central Armed Police Service. It is expected that necessary steps will be taken for appointment of commissioner by giving this committee. Hearing of this matter, this matter on 29 January.
Much obliged. Grateful to Lord.
Item number 3.
I am for the petition.
I am for CSTC led by Mr. Bihani.
Placed by the CSTC authority.
It appears.
Your Lordship, on last occasion directed us to file a report. Lordship, report is ready, Lordship. I am filing it today. Lordship, kindly come once, Lordship, paragraph 5, Lordship, of my report. First page, Lordship. Sir. The total due is 1,03,33,441. And amount paid to the petitioner, that is 20,67,000. That is on 29th April 2025. And Lordship, the payment would be made
Take amount payable
56,26,000.
Directly to me. Directly to me, my lord. They are required to pay directly to me. Rupees 56,26,619.
whatever.
Well, that
Lordship,
is
that is
transferred.
that is transferred to the EPO.
Lordship, can come to page 34.
EPO.
Yes. That will solve.
Yes, yes,
Yes.
Lordship.
The 20, no,
The 26 lakh 67 already
Paid,
paid, already paid. Yes, Lordship.
it is staff fund.
EPFO. Lordship, kindly, not transfer, Lordship. Kindly see the next
It is
page,
my-
Lordship. Next page, Lordship. Page number 2, Lordship.
Yes.
Lordship, now, Lordship, net amount he would be received, Lordship, 56 lakhs 26,619 from the corporation. We'll pay. We'll pay the amount.
And Muller, that amount to the EPFO. Rupees 26,39,820 as per demand notice. Yes. For transfer, transfer. Yes, yes. Exactly. Yes. Transfer.
Yes, yes. 822 transfer EPFO.
Pension.
Yes,
I have a two pension.
yes, Lordship.
Yes,
Yes.
Transfer. My lord.
As you wish. Provident Fund Organization. Scheme.
Yes.
Scheme. Huh.
Yes.
639 required to be transmitted
to the FAO, Employee Provident Fund Organization.
Employees Provident Fund Organization.
In terms of demand notice, my lord, at page 37.
Or payment of pension under employees
Provident Fund Scheme.
employees pension scheme.
As amended, my lord.
As considering the report participant, board directs concerned authority or corporation to release the from time. Allowing by months from the issue by 6 weeks.
Very also very
By agents for the data form.
Great.
Next paragraph, concern of corporation solving. Respondent number 5.
in terms of demand notice.
That email by the but not better than of the data formulation of the order for early use of data that are approved of
Demand notice.
employees provident
Great.
Lord, kindly give a one default clause in respect of payment, non-payment.
Great.
Item number 4.
The present report.
Well, as per the last direction, I have communicated the order. Thereafter, the AIMS Kolani Fund. Question. কাগজ কেটে গেলে মুশকিল। That is acceptable as per the guideline. Gosh. And the conclusion part also, I think. And the conclusion part, your lordship, I am not going through the
Copy of the report. Lordship. Grateful.
My lord, may I say one thing, my lord, prior to dictating the order? My lord, grateful one. But in the meantime, they will publish. I think two persons reporter and supplied along with next matter also. I think both the report has filed because I have not received any other postal receipt or come.
What is the name of other candidate?
Other candidate is Pooja Chourashia. I think, my lord. That is because two next matter, my lord, I have received only one postal come. I I don't. Both the petitioner was called for the on the same date, I think. That's why.
রিপোর্টের কপি আছে এক্সট্রা দিয়ে দেবো
কালকের মধ্যে দিয়ে দেব। WPA 277.
furnished by concerned sciences and he just
Item number 5.
5, may I please, Your Lordship?
জেরক্স করে দিয়ে দেবো এখনই জেরক্স এটা হয়ে যাবে দুটো একসাথে
5 আছে? 5 হচ্ছে। ওটা হবে কি? Yes, my KNS is acceptable. Mild and moderate is acceptable as per the guideline.
Item number 6.
May I please, Your Lordship, I am
For the respondent.
it has something. My lord, as per the, my lord, I have used a supplementary affidavit in this matter. You kindly take it on record. And I am filing the supplementary affidavit annexing the medical document of the government hospital. For my duty, my lord. Sir.
Mine.
My lord, please. Page 21 is the initial, 21. My lord, 21 is the detailed medical examination report where it has been deformity is one the detailed medical examination, bow leg, and the review medical examination, but bow leg and bilateral little finger ex extension deformity. My lord, this bilateral little finger extension deformity, there is no such indication in the medical guideline. Bow leg is there, is there, but the measurement is there. It is within 7 centimeter. It is acceptable. They have measured 7 centimeter, and that is acceptable.
This is from JNM Hospital, a government hospital, my lord, which says that they,
And on the same,
along with the report is also there.
my lord,
Both bow leg and little finger. The words BL is there. The earlier sentence says distance. There are two grounds of rejection, madam. Both bow leg and little finger. Distance between legs is more than 7 centimeters. I'm sorry.
Because commissioner was sent to hospital as well as his diagnostic center. And this distance, but
That's why that's
now they are saying that after
Malad, there is a confusion of the Malad, Malad medical. Malad, the page 23 of REIT application kindly first come to first Malad আর দাঁড়ান না জিজ্ঞেস করেছি একটু বলতে দিন Malad Malad kindly come to first Malad first kindly come to Malad then read it. Malad page 23 also I have annexed the documents.
It's come to page 3, which you have annexed.
Here. Malad, here Malad page 3 is the medical document given by the JNM hospital.
Yes.
Whereby
Then only like
the last line petitioner is fit in view of the orthopedical point of view. Malad page 23 of my read. It will these documents will corroborate it with page 23. Yes. Malad kindly have a look on the date. Page 23 of my REIT application. Page date to 2nd November 2024. Malad, this similar ground has been assigned bow leg. And the found the review medical examination board found mild bow leg. That is the clause 2 numerical 2 mild bow leg and declared fit. These two documents will corroborate it that I have a mild 2024.
That will not do. Because you have to show the present.
Malad, this is bow leg is the not a disease.
Present situation.
Malad, in that regard, my submission will be that Malad, this is not a disease. Present selection process is review medical page 22. 1st December 2025. Malad, they opined that this is bow leg. And their authority, the review medical examination board on 26th. They are also not saying that my bowling intermediate distance is such and such centimeter. They are also confused. That's why I am saying before your lordships, as per the Supreme Court judgment and this honorable division bench judgment, that this matter should be referred to any other.
I am
need to measure the calculate
the
the
very genuineness of the report. But probably this is a different person altogether. I'll demonstrate why. My lord will kindly take up page.
Saurabh Nath.
Showed Nath, the same person on the person. My lord will kindly come to the affidavit that says 26 years as on 9 December 2025. The report annexed with the supplementary affidavit says 25 years as on 9 December 2025. Not the same person. And the report which I have submitted of the same hospital, JNM hospital, that is 26 years. It is not the same person. Maybe the name is same, but the person cannot be the same. A person's age cannot decrease with time. When it comes to our instructions,
Did not require any Google searching. There is a specific, the guideline is very specific. Clause C is says that mild bow leg is acceptable within the 7 centimeters.
And in any
nowhere in the report and the test there is a particular mentioning that the bow leg is such and such centimeter. And as per the Supreme Court the direction and the honorable division bench direction, this case is fit for refer
And when it
to
comes
any
to
other authority to
deformities,
only for calculate the or
when
measure
it comes to
the
deformity, the guidelines is at page 21 of the guidelines, which says a simple deformity will also disqualify. That is also at page 21 of the guidelines. PC.
Moreover, may I please submit one thing, my lord? My lord, the review medical board has only 5 centimeter, my lord, the wooden board for by which they have measured the intermediate distance of the leg. My lord, how they come to the conclusion that this centimeter, this my lord, the difference this between the intermediate distance is 7 centimeter, more than 7 centimeter. This I am putting this question to myself. Medical guidelines says they have only 5 centimeter wooden board by which they will measure the distance of the intermediate leg.
It's clear that the little finger is also deformed. By that on that.
My lord, may I place the judgment, both the judgments? My lord, that your lordship knows the honorable Supreme Court judgment and the division bill to Ganguly. Your lordship knows.
intercondylar distance is so according to the respondents as per revised medical guidelines bullying is another grounds for declaring or for declaring intercondylar distance more than 6. Next, have you considered the submission state and the documents include here the appeals that it was really and was and really get and however, it is disclosed in the report that after multiple development and examination by was found that he had of model cells. Related to deformity that is knowledge, find in research that is intercondylar distance over the cells. That is the ground of rejection. So, next, and in order to assess assess of the candidate, both things like the report of it is 9 December 21st, which is enclosed to the submitting page. Does not have which is enclosed to submitting page as relied on behalf of petitioner does not clarify or does not disclose measurement of intercondylar distance in order to investigate whether code is needs to be or whether code is found to be on the contrary. that orthopedics and JB hospital measure bowlegs of the petitioner. Measure that on 70 meter kilometer distance can be on the scale. But it does not mean this during medical review. It was found by the
জেএনএম হসপিটাল মেপেছে তো? এ তো রেফারেন্স ফাইন্ডিং তো এইটা।
As there is no other medical, as there is no other medical document which authorities are finding of the past to the in relation to the hospital distance. Rely on the findings of medical exam based on next paragraph.
খিজিমে মেপেছে? খিজিমে ক্লিয়ার না।
On behalf of the Reliance next slide. On behalf of the Reliance on it is seeking November 2024. Yes. Demonstrate that commissioner was declared and considering present selection process of was not declared on the ground of on the ground of by very that
Much obliged, Your Lordship.
Item number 7.
Lordship, item number 7 and 8 are the totally same analogous issues, my lord. If Lordship pleases to take up the item 8, which is it is presented, my lord, and it is not properly presented. For this reasons, I am. আমারটা পেজ মার্ক করা আছে।
Lordship, 8 time for the state, Lordship.
7, Lord, so far as 7 is concerned,
You are appearing for the state.
7. And my land is appearing for 8. But if your Lordship from the prayer, Lord, in the prayer, Lord, because it is the second round litigation. First round, Lord, a coordinate bench has been pleased to pass an order disposing of the writ petition, directing the authority to consider independently without, because this honorable court did not touch the merits, but consider that this reason order has been passed, and pursuant to that, the government order has been passed. My land print has challenged both. But I have, though, my lord, I have brought the instructions, not signed.
But this is signed, Lordship.
Not.
It is not signed, virtual, my lord, instructions. Not, my lord, I am not filing this. These instructions for, my lord, addressing the court, what is the actual stand of the government. But, Lord, so far as subject to correction, Lord, is requires affidavit, because some documents I have to disclose before your Lordship. Why this order was passed? Because it is a
What is the matter? What is the
casual engagement without sanctioned post. Honorarium was given.
Where working?
1994.
Where working? Petitioner is working.
This is child. This is the respond number under respond number 7.
এই দাও তো 8টা ওনার সুবিধা হয় নাম্বার 8টা দেখি
Rafi. But Lord, what has happened subsequently, my lord knows 2011 government, honorable government of West Bengal issued a notice of finance
enhancement of remuneration
and consolidated.
16 September 2011 remuneration.
Yes, Lord, that is, Lord, pursuant to that, Lord, his engagement has been calculated 2011. But Lord, he is asking for from 1994, which can't be, Lord, because of this notification.
So from 2011 it has been given?
Yes, I have given. We have given. But that is why, Lord,
yes.
If it is
Lordship, may I submit the report?
Obliged to your Lordship for accommodation.
Lordship, may I submit the report?
Just a minute. Okay. Let him place his case. It is his petition. What is going on? Please take your seat. Yes.
Lordship, I am initially placing the government's decision with regards to my position in the posting, my lord. It's paid.
Now, where is the decision which has been taken in terms of the order of the court? Where is the decision? Because there is a previous order dated 28 August 2025
page
by a coordinate bench.
Yes, ma'am. Page 91.
Now, pursuant thereto, an order has been passed by the authority on 1st of December 2025. Just a minute. So benefits have been extended to the petitioner from 1st of August 2011. Now you are seeking benefit from 13 June 1994.
No, my lord, this is not the only issue, my lord. Major issue, my lord. If I go back to the 11 order, my lord, what was the issued by the finance department, this is a very beneficial order towards the at least to the tenure of security of service of the persons who are in daily wages, contractuals, casuals, all these people, my lord. And this very order and how this order remains effective, and not only to my case, to each and all in my positions, my lord. This is the thing I beg to canvass on this issue, my lord. But my submission on this point was initial stage, my lord. This very order has been taken into cognizance by the department itself, not by the directorate. The department as a policy decision. Department is the policy decision making body, my lord. And in this sequence, my lord, I would lordship's attention to the annexed P2, my lord.
You are working as
Now as a teacher, my lord, contractual teacher, my lord.
teacher.
As
Where?
teacher. At different dam school, home, my lord. And this is at Surjodaya different dam schools within Uttar Dinajpur.
As contractual teacher.
As teacher, man.
Where is your appointment?
My appointment was
As
initially,
teacher.
I was appointed as a in honorary capacity.
Show me your appointment.
Appointment letter is not original copy is not with me, my lord. My submission in this context, my lord.
Just a minute. If you are a teacher on casual basis, then how the writ petition is maintainable under Group 6?
Because, my lord, this is the home, my lord. Where is that?
Maybe that it comes under the head of other educational matters.
This is,
It's not a service matter.
firstly, my lord, this is not under education department or any of the wings of the education.
Maybe, but this comes under the other educational matters.
But it is not purely. This is basically training.
You have
and
stated in
skill
paragraph
development.
2. You have stated in paragraph 2 that your petitioner has been working as teacher on casual basis.
Yes, my lord. This is the. This
So
is
if
the
you are a teacher, then I have no I cannot take up this matter.
Lordship, in the previous occasion, Lordship was pleased to this basic issue came up for consideration, and Lordship was pleased to pass and.
But this issue may not have been raised. Court is raising this issue. If you are a teacher, then court cannot take up this matter.
This is just a nomenclature, man. I have been there to train them up for some skill development because that is the home, not in the institution.
Education matters are divided into 4 parts. One is higher education and university, another is secondary and higher secondary education, another is primary education, another is other education matters. It will come under other education matters.
It is not the school. My lord, if Lordship, my lord, it is
it is averred in the writ petition that petitioner is working as teacher on casual basis. Stop. Hence, writ petition stands released due to want of determination and be placed before the bench, before the appropriate bench. Stop. Stop. Before first sentence টা একবার বলো তো। It is averred in paragraph 2 of the writ petition that petitioner is working as teacher on casual basis. Stop. The বাকিটা কেটে দাও. Stop. Therefore, the writ petition. Therefore, the issue involved in this writ petition is therefore, the issue involved in this writ petition relates to education. Stop. Hence, writ petition stands released due to want of determination and be placed before the appropriate bench. Next paragraph. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the presentation form and pro forma page of the writ petition and to reclassify the writ petition as group 2 matter. No, you take it back. You take it back. So both are same. Teacher in home.
Teacher in home, my lord.
Same order in 7 and 8. দেখি ও স্টেটমেন্ট পড়েছে কিনা। Yes. Same order. Yes, call the next matter.
Item number 9.
9. Lordship, I am.
Who is
May I
appearing for
file
the
a
respondent?
supplementary affidavit?
Who is appearing for the respondent?
My lord, Joshojit Mukherjee,
Where
Mr.
is he?
Joshojit. I have not seen even from morning.
Issue. Supplementary affidavit filed on behalf of the petitioner is taken on record. Next, however, Union of India is not represented today. Next paragraph. Hearing of this matter stands adjourned. Stop. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing Union of India. Learned advocate representing Union of India by January 2026. Stop. List the matter under the same heading for further consideration on 27th January 2026.
Much obliged.
Item number 10.
10, may I please, Your Lordship? I have.
Supplementary affidavit.
There is, I am not paid for any, I think I am not paid for any supplementary affidavit in this matter because I have annexed the document with the writ petition.
Issue. Today's supplementary stop. Learned advocate representing the petitioner submits that petitioner is not willing to file supplementary affidavit. Stop. Or is Union of India is not next paragraph. Union of India is not represented by learned advocate. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing Union of India by 19th January 2026. Stop. List the matter under the same heading for further consideration on 4th February 2026. Next.
Item number 11.
11, I appear for the writ petition, my lord. I was praying before your lordships for filing of a supplementary affidavit, my lord. There are two issues with regard to the.
What about the other side?
Lord, Mr. Partho Ghosh is appearing.
Mr. Joshojit Mukherjee.
Yes, he had also appeared in the last occasion.
No,
but although I have not sought for
notice, come back.
May I have the supplementary affidavit filed pursuant to your lordship's kind leave? I have not sought for a leave previously. I may also serve the supplementary affidavit.
So why you are
for the reasons
why you want to file supplementary?
For reasons, my lord, to demonstrate before your lordships the carrying angle, left-hand carrying angle difficulties were adjudicated in the preliminary my lord, test. Thereafter, after the review medical board was conducted, my lord, so report varied from the same particular organization which they have sought to be have the report done. I had also done my report from the said organization, which is now suggesting that I am coming within the zone of consideration. Just to demonstrate that before your lordships, my lord.
We will file it.
No.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Next paragraph. However, Union of India is not represented by learned advocate. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing Union of India by 19 January 2026. Stop. Next paragraph. List the matter under the same heading for further consideration on 4th February 2026. Next.
Item number 12.
I have passed an order. Let the order be signed, and then I will take.
I also inquired just now that order notice.
I have delivered a judgment in open court. Let the order be made ready, signed, and hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 4th February 2026.
May I read one thing? Because of that, Malad is well aware the fact this is regarding the selection process of junior engineer. The validity of panel is a crucial thing. The subject matter in this instant petition is that all the petitioner here they are the disabled candidate. There are still some seats are vacant. So they want the appointment because Malad is well aware the fact that under the Disability Act 2016, 4% reservation, that is their right. So it will be kind enough if they considered in the meanwhile, because they made a representation.
Well, let me come back.
Happened, my lord, with
You obtain instruction in the meantime.
Because of that, if the
on behalf of Public Service Commission.
Yes.
In the meantime, nothing would be happening.
Who is appearing for the state respondents?
The last occasion,
Tarok Koron
last
appeared for the
occasion,
state
Tarok,
respondents.
Mr. Tarok Koron appeared.
You have nothing to do in this matter.
No, I am the answering respondent.
So then,
I am saying that nothing can be happened with regard to the filling of that vacant post, lordship. In the meantime,
when the selection process is, when the panel was prepared,
panel was prepared in the selection
As per
process
my-
commenced in the year 2022, and the panel was prepared.
Recommendation is 25th June 2025, which is annexed with my writ petition, page number 105.
so in 2022 panel was
No.
prepared. Still panel is
2022 initiation of selection process.
when panel prepared.
Panel was prepared in the year 2025.
2025.
June 2025.
25th
What
June
is the
2025.
lifespan of the panel?
1 year.
So up to June 2026, it is valid.
It is valid.
We'll come back on.
Page number 105.
Issue. At the time of call, at time of call, state respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 19 January 2026. Stop. List the matter under the same heading for further consideration on 4th February 2026.
Because they are disabled candidate. If something, because seats are vacant.
Yes.
That is their only plea.
Item number 13.
Item number 13 is compassionate appointment in government. But there is also the same question. What are resources? The compassionate
But
appointment.
what is the urgency in compassionate appointment?
There is
When the father died.
in this matter, reason order is passed. I challenge that reason order. That is
It's a matter relates to government service.
obviously sad.
So you file it when there will be a bench available. Unless and until matter is extremely urgent, I am not going to interfere in any matter.
Otherwise, I lose that. Might not be. It happened. Might not be. Appoint the judge in 1 year or something. Then the cause of action. Because delay is a fatal thing. Service matter. That's the reason I have to file it. As bless order uploaded as dimpit.
No, that will be, the decision has already been taken that the matters can be permitted to be moved before.
And I believe
when the when the West Bengal Administrative Tribunal is not functioning, but that does not mean that all the matters will be permitted to be will be entertained. Those matters which are very urgent, those will be considered. But this court will not be transformed into a tribunal.
No, not obviously, certainly not.
If
but
you have, if you
I-
can satisfy this court on the point of urgency, court will. Otherwise, not. You have to wait for some time till the tribunal is constituted, or till the appointments are made in the tribunal.
but the fact is that, my lord, in
Because what
service-
will happen if I give a direction for affidavits? In the meantime, and in the thereafter, say after 1 month, appointments are made. Then what will happen to this writ petition?
in that case, my lord, same thing happened when the matter is not suppose, my lord, there is a other bench, suppose Jalpaiguri bench. If Jalpaiguri bench is not in function, then, my lord, if urgency is that, my lord, when that is in function, but there is no such certainty in this matter because of tribunal. When the tribunal will
No, I am asking you very well. Today, if I give a direction for filing
then
affidavits,
it will
now after after 4 weeks, if appointments are made in the tribunal, then these petitions are not maintainable before this court.
then
Then what will
I have
happen
to
to
go.
this
I have to
petition?
in each and every matter they have to go. They have
Yes.
to go. They have each and every matter.
So
Then
this
they have to go.
it will create a complication
Not
because
with
matter
greatest of
will
the-
go down to the department and nobody will be there to point it out, and this matter will be kept pending
But
indefinitely.
with greatest of respect.
So therefore, unless and until you can satisfy me on the point of
Yes, yes,
urgency, I am not going to interfere in
yes,
any matter.
yes. Yes.
Record an order. List matter is heard in presence of the learned advocates representing the petitioner. Mr. Dey, you are appointed for the state respondents. List the matter under the same heading for further consideration on 11th February 2026.
Just for my satisfaction, my lord, all the pardon me, my lord. I believe, my lord, my junior informed that my lord views is that, my lord, in single bench matter is maintained.
Yes. That I have dictated the judgment in open court.
I am grateful, my lord. And I talked to several, my lord, as well as Mr. Bhattacharya, that same views.
So wait for the judgment instead
yes,
of getting a clarification from this court. Yes.
Yes. Grateful, man.
Yes.
Grateful.
Item number 14.
My lord, I am for the petitioner, my lord. My lord, the husband of the petitioner expired, my lord, in hardness, my lord. My lord, she is seeking, my lord, compassionate appointment. That application is pending for.
Yes.
Well, this matter may not be so simple like that, my lord. Actually, what happened? There is a writ petition still pending before this honorable court, filed by the father of the deceased employee, alleging that the petitioner has murdered the son. Why the police is not taking action against the police inaction? Alleged
The petitioner, wife.
No, father of the petitioner, father of the deceased, father-in-law of the petitioner, father of the deceased.
In this writ petition, who is the petitioner? How he is related to the deceased?
Wife of the deceased.
Wife.
That is what
Wife
I'm
of the
asking.
deceased. Wife of the deceased, my lord. Now, my lord, we are not yet aware. We are not a party in that writ petition. I am having a copy of the writ petition with me, but we are not a party in that writ petition. Bank is not a party.
But you process,
But
take
my lord,
steps for processing the
we have
application
also written a letter to the
for
police
appointment on compassionate ground.
on the police authorities whether it is FIR is pending against her or not.
Ultimately, petitioner is convicted, then you take steps in accordance with law.
My lord, if the petitioner
No.
files
This
any
is not the correct stand.
if the petitioner files any affidavits,
If for any reason
declaring-
the writ petition is pending, alleging that the petitioner is the murderer, then no order is passed for which you cannot delay the appointment on compassionate ground. That will be you can appoint the petitioner subject to result of this writ petition.
my lord. And my lord,
Subject to
we
result
also
of the writ
also
petition.
not aware.
Is it not known to you?
My lord, we are also not aware whether any FIR has been registered against.
You need not be aware because you are not the complainant.
No.
So if ultimately petitioner is if the petitioner is convicted, then you take steps in accordance with law. You add a rider in your appointment letter that the
My lord,
appointment shall abide by the result of this writ petition.
My lord, if my lord observes this, my lord.
No, I will not observe anything. I will direct you to take steps for appointment of the petitioner.
In accordance with our policy.
Yes, tell me the facts.
The husband of the petitioner, my lord, died in 1st January 2024, my lord.
1st January.
Yes, my lord. 2024, my lord, he was outside the house, my lord.
Husband died on
1st January 2024.
Yes, then
When he was in outside, my lord.
very well, died in harness.
Harness.
In harness. Then when you made an application for appointment on compassionate ground,
My lord, 21st September 2024.
where is that application? Page 11? Yes.
Page 11 onwards, my lord.
21st September 2024.
Yes, my lord.
Wait, I'll show you.
Yes, what steps you have taken on this application?
My lord, we have processed this, but only we are waiting for this. Not that was our mistake, perhaps, as my lord rightly pointed out.
Suppose the writ petition is kept pending for 5 years and thereafter it is dismissed. Then what the lady will do?
No, we are not about a writ petition, my lord. We wanted to know from the police station. We have written a letter to the police station. We wanted to know whether any FIR is pending or not. Whether that is right or wrong, my lord has rightly said that you should not have waited for that.
Are you aware of the particulars of that?
Yes, we have been told by the father of the deceased. My lord, kindly sees in our letter we have also mentioned. We have been told by the father of the deceased.
Where is that letter?
My lord, I am not carrying that letter with me, but kindly we have referred to that in our complaint to the in our representation to the police station, my lord. Kindly sees, my lord, the 3rd paragraph, my lord.
Page. Is it part of the record?
No. ব্যাংকে দেয়নি, এটাই তো কথা। না ব্যাংক চেয়েছে, ব্যাংকে দেয়নি। On 9th May 2025.
What is the petition number?
2637/2024.
3418 of 2024, my lord.
Petitioner is party to in that writ petition, my lord.
Where from you are getting this? Is a filing a number F26371?
No, it is the final number is 26418. 26418, my lord. In fact, my lord, there is no mention about this writ petition in this
letter. There is no. It is not mentioned.
In this writ petition, in the instant writ petition, there is no mention.
This letter, it is not mentioned. The writ petition number.
No, we got the filing number at that point of time. We had the filing number. Thereafter, we inquired and we found the present writ petition, which has now been renumbered as 26418.
Just a minute.
26418 of 2024. 2024. Filed by the father of the deceased.
My police report, everything okay, my lord. Regarding the management, regarding the death of my lord, report is heart attack, my lord.
Issue. Bank of India. Affidavit of service.
I have already filed, my lord.
Husband of the petitioner was employee of Sajirhat branch of Bank of India, who died in harness. Sajirhat, who died in harness on 1st January 2024. Stop. Petitioner being widow applied for appointment on compassionate ground in prescribed pro forma on 21st September 2024, and it is submitted that till date no steps have been taken to take decision on said application of the petitioner seeking appointment on compassionate ground. Petitioner prays for direction upon the concerned authorities of bank to appoint her on compassionate ground. Next paragraph. Mr. Devashish Ghosh, Shah. Mr. Devashish Shah, learned advocate, represents represents bank authority and submits that as per relevant scheme relating to appointment of compassionate ground, application of the petitioner dated 21st September 2024 may be considered, but there is one impediment, as one writ petition being WPA 26418 of 2024 is pending at the instance of the father of deceased employee. Stop. It is also submitted in reference to a letter dated 5th January 2026 issued on behalf of Bank of India and addressed to officer in charge Iqbalpur Police Station, Kolkata, that certain allegations are leveled against the petitioner in the writ petition filed by petitioner's father-in-law, and the said writ petition is still pending. Next paragraph. Nothing is shown during course of hearing that petitioner is found to be responsible for any offense as alleged in the aforesaid writ petition, which was filed by her father-in-law. However, it is submitted that the writ petition is still pending. Next paragraph. In view of aforesaid situation, concerned authority of Bank of India is directed to decide application of the petitioner dated 21st September 2024 seeking appointment on compassionate ground by 8 weeks from the date of communication of this order. Stop. If it is decided that petitioner is found eligible to be appointed on compassionate ground under the relevant scheme, petitioner shall be appointed subject to result of the pending writ petition being WPA 26418 of 2024. Stop. Next paragraph. With the aforesaid directions, writ petition stands disposed of. আচ্ছা আরেকটা জিনিস করে copy of the letter তাও তো copy of the letter dated 5th January 2026 issued on behalf of the bank authority addressed to the officer in charge Iqbalpur Police Station is taken on.
Item number 15.
The petition.
I am for CSTC led by Mr. Nihan.
This is a matter regarding the enhancement of the leave salary from 180 days to 300 days, Your Lordship. My Lord, I'm covered by my Lord's order in this respect. Only I'm seeking for a liberty to file to make a representation before the authority concerned. In that order, Your Lordship, the petitioners already made a representation. My Lord directed them to consider the same. So, but in my case, Your Lordship, there is no representation. So I'm seeking a liberty.
When retired?
Lordship, I retired from service on 28th of February 2019.
You are seeking leave salary for another 120 days.
120 days, Your Lordship.
Calcutta State Transport Corporation.
Yes.
You are for the state.
Yes, my lord.
এসো ইট ইজ সাবমিট নেক্সট এই অবধি ঠিক আছে কারেকশনস গুলো দেখে নেবে স্টেট এখানে অ্যাপিয়ার করছে আগেরটা স্টেট ছিল না এবার প্যারাগ্রাফ কোডটা চেঞ্জ হয়ে যাবে it is submitted on behalf of respondent on behalf of corporation if approach is made on behalf of the petitioner to the corporation. If approach is made on behalf of the petitioner to the corporation seeking consolidation of leave salary based on on calculation of 300 days, not 180 days. In that event, same may be considered by the concerned authority of corporation. Next paragraph. Having considered the respective submissions made on behalf of the parties, court finds no purpose would be subserved in keeping this writ petition pending. Next paragraph. Leave is granted to the petitioner to make a representation to Chairman Calcutta, Managing Director, to the Managing Director Calcutta, to the Managing Director of the corporation being response number 5, seeking payment of leave salary for 300 days, not 180 days, by fortnight from date. So if such representation is made within the aforesaid time, response number 5 shall decide the same in accordance with law by 12 weeks thereafter, and decision to be communicated to the petitioner by 10 days thereafter. Stop. Response number 5 shall pass a reasoned order. Stop. Next paragraph. In the event decision is taken to এটাকে করে দেব এটাকে সেট আউট করুন রিকোয়েস্ট হ্যাঁ হ্যাঁ পরের প্যারাগ্রাফে এই তিনটে প্যারাগ্রাফ লাস্ট সেট আউট করুন ডিসপোজড অফ
Item number 16.
16 while I beg to appear for the state.
Only the date of retirement is to be changed.
When retired? When retired?
I retired on 30th of June 2024.
30th June 2024. You are seeking leave salary for more for 120 days more.
Lordship. A representation already been made, Your Lordship.
You have made representation.
Where is the my lord?
Lordship,
Yes.
Page 20, page 20, Lordship.
Your Lordship.
Annexed P5, my lord, annexed at page 20.
Yes.
On 1st of August 2025, they had made a representation, my lord, to the managing director of the respondent number 5. It has been made but not been considered.
Yes. Disposed of. State respondents represented ওটা করা আছে দেখে নেন কারেকশনস করা আছে না 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 এখানে রিপ্রেজেন্টেশন আছে ওই অর্ডারটা ধরে হবে
Item number 17.
For the state.
Yes.
In this repetition, I'm paying for 80% of my provident fund with interest and the interest on my gratuity only.
Yes.
This is my lord's order.
Retired on
Retired on 31st of December 2024.
You are claiming 80% PF
PF
and
Along with
80%
interest.
PF with interest and interest on gratuity.
so interest on PF and gratuity.
PF and
Interest on unpaid PF and gratuity.
Lordship. Actually, Your Lordship, I am entitled to get interest on the whole provident fund also. 20% also paid belatedly.
The 20% was also paid belatedly.
Lordship, everything.
Then interest on PF and gratuity.
Interest on PF and interest on gratuity.
You are retired on 31st December 2024.
Yes.
And provident fund was paid, my lord, 31st January 2025.
20%.
So delay
19 days.
So during for that period, his petitioner is entitled to get interest.
No doubt. At the date of retirement, gratuity.
But the
and
period is
provident
too
fund
short. You are submitting period is too short.
What 20%?
It will not inure to the benefit of the petitioner. Calcutta State Transport Corporation.
দিতে পারছি না পার্ট না দিলে আমার এই কন্টেন্ট ফাইল
Disposed of. এটা দেখে করে দেবে same.
But I am with my junior Jonathan.
Yes, yes, give your evidence.
Item number 18.
Item number 18, I am paying for 80% of my provident fund and interest on the whole amount of provident fund.
Retired on
Retired on 30th of June 2023.
30th June 2023. 80% provident fund.
And interest on the entire provident fund.
Interest on PF.
PF, only PF. But I have handed over the order, this is the same one.
State, give your evidence. June 2023. Disposed of.
Item number 19.
19, my lord, I am appealing for that. Here the petitioner claim for family pension. The petitioner is a divorcee daughter. My lord, and the father, my lord, working under the office of the Kolkata Port Trust.
Who is appearing for Kolkata Port Trust?
Master, I serve.
You are appearing for Port Trust?
My lord,
Yes, yes, place your case.
the father of the petitioner, my lord, retired from service in the year 2001. And my lord,
Retired on
2001.
date?
My lord, that is, date is not there because my lord,
2001 had 12 months.
my lord, yes, my lord, the incomplete, my lord, papers are before the petitioner because he is now, my lord, of starvation. For that reason, my lord, papers are, my lord.
2001, then what happened?
Then, my lord, the father of the petitioner died, my lord, on 16/6/2014. That death certificate I annexed.
Died on 16th June.
16 June 2014.
Retired on 1st January.
Allow her.
Of course, I'm just giving the
Yes. 16 June, then
16 June. And pension earlier papers, in the pension papers, name of the petitioner was appeared. If your lordship kindly see page 16, the name and address of other nominee in case of the nominee's case, the nominee under column 1, predecessors, the pensioner. The name of the petitioner is appeared. Page 16.
petitioner is the daughter.
Daughter, only daughter. Divorcee daughter. But that is Srimati Reba Chakraborty, page 16. Malat, column number 5.
Yes, yes,
Column number 5.
yes.
And my lord, death certificate of the father is my lord page 18. 180.
But the name and address of the nominee in the first column is another lady.
Another lady, that is mother, already died. My lord, page 70 is the death certificate of the mother, who died in the year 2009. Prior
Mother died in 2009.
2009, prior death of the father.
Yes, then.
And
So after 2014, have you made any application for release of family?
Application made, and in the year 2021, they intimated me that my proposal has already been rejected, but no intimation has been given to me.
Where is that?
Page 41. Page 41, that is intimated me on 5th March 2021. And if your lordship kindly see, please note that these officers already communicated the decision of SMP Kolkata regarding your claim by letter dated such and such, that was deleted. Then 24th 5 2019. And in the year 2019, Mala, no intimation.
So now,
has been.
then you have to challenge that rejection order.
Mala, that rejection order not with me. That was
On
not
page
handed
33.
over. That is another.
33.
Your lordship's kindly see page 33. Page 33. Mala,
But that is not the letter dated 24th May 2019.
Well, in the date, my lord, it has been intimated that the claim for rejection. Why that her claim was rejected? Because her father died, my lord, prior to getting filing the divorce application. Her father died on 2014, June, 16 June 2014, and he made an application for getting the degree of divorce in 2015, September 2014, after lapse of 3 months. So that's why, my lord, she is not eligible to get the family pension, because she made an application after the death of his father.
So three categories of the daughters of three categories are entitled to get family benefits. This unmarried daughter, divorced daughter, and widowed daughter. Now, suppose it is a case of widowed daughter. Now, at the time of death of the employee, daughter had husband. Daughter was married. Now, if daughter lost her husband after death of the employee, she will not get family pension.
At the date of time of the alive of his
How
father,
does it make a difference?
he's not different. He's not the dependent. Well, kindly come to page 42.
But after divorce, why petitioner will not be made eligible? Will not be found eligible?
Because she was not dependent at that time. She was dependent on.
Show me the provision relating to
Well, kindly come to 42.
family pension. Scheme relating to family pension. That on that ground you can reject. Other departments are releasing it.
Here, my lord,
it doesn't make any sense. Till that petitioner or till the daughter remains married, she is not entitled. But after losing husband, why she will not? It's a beneficial legislation.
Yes, my lord.
It's a beneficial scheme. It should be interpreted liberally.
Yes, my lord.
Not in this fashion.
But my lord, she should be eligible on the date of.
I am asking you that yes, she was not eligible. She had husband. But after death of husband and after death of her father, husband was alive. After death of husband, why she will not get the benefit?
She should establish.
It's a beneficial scheme. It should be interpreted liberally.
She should be. She should establish that she is the dependent of his father. Well, see if she has means, my lord, of his husband.
Tell me that what are the means she had after losing her husband?
The eligibility.
Is she a working lady?
Well, suppose, my lord, I'm submitting, my lord, before your lordship, my lord, I'm putting question myself, my lord, because, my lord, husband
Just
has
a
a
minute.
landed property, other source, my lord.
Wait,
My lord, page 42.
please wait. Yes, para 4 of memorandum dated 11 September 2013. Where is that?
That is I annex page
My lord,
42.
that is 42.
That is not applicable to
Page 42.
your lordship kindness. Page 42. I annexed. First para, last one.
Paragraph 4.
Why it is not applicable?
My lord, provisions for grant of family pension to a widow divorced daughter beyond the age of 25 years has been made by OM dated 13/8/2004. This provision has been included in clause 3 of sub-rule 54(6) of the CCS pension rules 1972. For settlement of old cases, it was clarified by OM dated 28/4/2011 that the family pension may be granted to eligible widow divorced daughter with effect from 13/8/2004 in case the death of the government servant pensioner occurred before this date.
That is one aspect.
Yes.
That is not the only issue in this office memorandum.
They are
It said for settlement of all cases, this procedure should be followed. But provided that provision for grant of family pension of a widow divorced daughter beyond age of has been made by VDA office memorandum dated so and so, this provision has been included in clause so and so 54(6) of CCS pension. This is the general procedure. And in case of old cases, this methodology will follow. So therefore, it is applicable. Now, which paragraph is
Paragraph 4, my lord, in the middle portion, first, second, third, fourth line. My lord,
just
Lord, it is clarified.
Yes, read paragraph 4.
It is clarified that the family pension is payable to the children as they are considered to be dependent on the government servant pensioner or her spouse, a child who is not earning equal to or more than the sum of minimum family pension and dearness relief thereon is considered to be dependent on his or her parents. Therefore, only those children who are dependent and meet other conditions of eligibility for family pension.
At the time of death of the government, sir.
Yes, page 19, my lord, kindly see for a moment.
So you are not dependent at the time of death of the.
Before that, from the year 1992.
Your husband was alive.
My lord, divorce petition has been filed in the year 2014, mutual divorce. Prior to that, I am residing at my father's house, page 19. Marriage solemnized in the year 84.
Page.
Page 19.
19.
Page 19. That is the resolution taken by
The mutual divorce.
Mutual divorce, and that was filed in the year 2014. 19 is the
And the divorce decree was passed.
2015. My lord, page 20. Page 20 and 21. Page 20, order passed on 27 March 2015. And 21, order Matsude number 2124 of 2014. And from the first para,
This is a letter issued by the Panchayat Authority in 1992.
as per my lord, provision of the
So from which date you are living separately?
1992.
92.
92. And as per provision of the 13B, my lord, the provision is, my lord, mutual consent allow spouses to jointly petition for divorce if living separately for over a year. My lord, I filed in the year 2014. As per 13B provision, my lord, I have to live separately
For 6 months.
1 year.
1 year.
That if my divorce has been occurred in the year 2014, filed 2014, my lord, then I.
Where from you are getting the date of filing the divorce petition on mutual ground?
My lord, divorce petition, my lord, date was not given, my lord, only year has been given, Matsude number 2124 of 2014. That your lordship got
Page 20.
21. 21
Page
order.
20.
20 also. Yes.
Page 20 in the cost title.
Yes, 2124 of 2014.
Just a minute. What is well?
If 2014 has been filed, then my lord, from 2013, we will reside separately. As per provision of the 13B of the Hindu Marriage Act.
Yes. Now it is recorded in the divorce decree dated 27th March 2015 that petitioners are residing separately for more than 1 year. Now, if they were living separately for more than 1 year, then it is to be the date is to be reckoned 27 March 2015. Go back another 1 year, then at least from March 2014 they are living separately. Now here father died on 16 June 2014. Prior to that, petitioner is living separately.
Kindly pause 1 minute, my lord. But if she is relying page 19, that is the marriage took place prior to 84. But kindly here her application, the divorce suit, my lord, the page, my lord,
Come back at
26.
Come back at 2.
Or 26. That's all.
Come back at 2.
Lordship.
তখন বিয়ের কোনো কাগজের নথিই নাই।
So therefore it appears.
I am relying on page number 19 that there is a mention that 1984 before that marriage was took place. And my lord, kindly come to my lord page
24
20.
marriage took place.
Yes, my lord, that is my lord. The দক্ষিণ গণিপুর নিবাসী মনোরঞ্জন চক্রবর্তী পিতা অনিল চক্রবর্তী সহিত তার স্ত্রী শ্রীমতী রেবা চক্রবর্তীর মধ্যে 1984 সাল হইতে স্বামী স্ত্রীর বিবাদ চলিতেছে 1984. And my lord, here my lord, in application of joint petition consent application, that is my lord, the date was formalized on 24th November 1996. And my lord,
date was
the date was mentioned on 24th November 1996. That is my lord, your lordship can get it from page 23 in the decree. And my lord, their application
page 20 is the decree. 27th March 2015.
But here, my lord, that's mentioning that marriage was formalized in 14/11/1996. In page, kindly come to page 23.
Relevant?
Relevant because, my lord, her marriage dispute was as per page 19, 1984.
Maybe
She was
continue.
stopped, my lord, after death when her father died in 2016. Thereafter, by 14, thereafter he 1 year after he 15 to file an application claiming that marriage tie was dissolved. It's a mutual divorce, not contesting, my lord. So after death of his marriage, so long time she sustained, and after death of his father, all on she suddenly she made an application for consent.
The application was filed
on top. That is, my lord. That is, my lord, page 24.
Divorce by mutual consent.
2014 that has been filed.
No, my lord,
date.
My lord, date was not.
No, what date is
Because
page 24. Page 24 and the top filed on 6 September 2014. Page 24 on the top filed on 6 September 2014.
So it was designed according to you.
Because, my lord, marriage was not solved.
Yes, page 24.
Yes, but page 24 at the top filed on
district.
September 2000.
Which district?
South Chosotara.
Page 20.
My lord.
Page 24.
Yes, my lord. Kindly see. Filed on 6 September 2014.
So 2014.
After died of his father, her father.
After father's date on 16 June 2014. This 13B.
Yes, my lord.
13B application was filed on 6 September 2014.
2014. And my lord, actual fact is this, my lord, the petitioner.
The question is whether it is designed or not.
My lord,
because you have
page 19.
You have filed an application. You have filed an document of 1992.
Yes, lord.
There was a marital discord which was continuing from 1992.
84.
So why just after the date father died on 16 June 2014?
Yes, my lord.
And application under 13B was filed on 6 September 2014.
My lord, these
June, July, August, September, within a span of 3 months.
My lord, page 19.
So death of father was catalyst in filing an application seeking mutual divorce.
That is not true, my lord. That was deposited. That was not submitted before the authority concerned.
Yes. I was about to pass an order, but now it appears to be convincing.
Actual fact.
From 1992, there is marital discord.
Yes.
Come to page 19.
Page 19. Yes.
It's again July 1992 and 13B application. When filed in September 2014.
6 September.
Father died on 16 June 2014.
That is, my lord, these documents are necessary for the husband.
For that, and even the date of solemnization of marriage, my lord, that is also incorrect.
You put it on affidavit. Supplement affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is a retired. Petitioner is a divorced daughter of a deceased divorced daughter who has approached this court with the present writ petition, inter alia, praying for direction for release of family pension in connection with service of her father, who was employee of Kolkata Port Trust. Stop. Father retired when father retired?
Father retired, my lord, 2000.
You are trying
My lord,
to
on 1st June, 1st January 2001.
then 31st of December 2000. 2000. 31st December 2000. Yes, sir. Father retired on superannuation on 31st December. Whose mobile is ringing? Bari jao. Father retired on superannuation on 31st December 2000 and received pension. Father died on 16 June 2014. Stop. Mother predeceased father in 2009. Stop. However, next paragraph. However, learned advocate representing port authorities in reference to a communication dated 29 September 2014 issued by Deputy Chief Accounts Officer within bracket OA close bracket for Financial Advisor and Chief Accounts Officer submitted that petitioner is not dependent daughter of the deceased employee. The petitioner is not a dependent daughter of the deceased pensioner. Stop. It is submitted that at the time of death of pensioner, petitioner was a married lady, and in order to get pension, filed matrimonial suit number 2124/2014 seeking mutual divorce on
Page 24.
6 September 2014. Whereas father of the petitioner একই সঙ্গে died on 16 June 2014. Stop. Petitioner obtained divorce degree on 27 March 2015 on mutual consent. Stop. Next paragraph. Whether petitioner was dependent upon his father at the time of father's death needs to be adjudicated after calling for affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging it. Diplomat.
My lord is generous regarding family pension and pension.
Date of filing 13B application is very significant. Means double.
My lord, prior that, my lord, the petitioner.
It is only possible in case of Dakhin 24 Pargona and Purbo Medinipur. Still, your lordship is.
92, my lord, this is the genuine document.
It is not a divorce divorce decree on contest. It's a mutual divorce. And when marital discord was there from 1992. It is surprising. Yes.
Petitioner is lucky and has got this.
Yes.
Milord, Milord, I'm extremely sorry, Milord. Milord,
Let's call the next matter.
Item number 20.
Paying for the petition, your lordship.
at the time of
Your lordship.
nothing and I appear to state.
My prayer
And for CSTC lordship.
payment of 80% of my provident fund and leave salary also. They have not paid my 80% provident fund and leave salary also. And gratuity was paid belated.
Yes, Mr. Prasad, what you are trying to mention?
Milord, item number 3, where your lordship has, Milord, the demand notice, Milord, by the CSTC to be, Milord, I was on legs in court number 1, Milord.
Item number
3, Milord. Milord, that's why, Milord, it has been disposed of.
You are representing Employees Provident Fund
Yes,
Organization.
Milord, that's why, Milord,
কে নিয়েছো? I don't know, তুমি নিয়েছো?
I'm grateful, your lordship.
It has already been signed.
Signed?
During recess.
সকালবেলা হয়েছে 11টা
Sorry. I have signed it during recess.
Yes.
Yes.
And petition retired from service on 31st of January 2025 from Calcutta State Transport Corporation. He has not been paid 80% of his provident.
When retired?
31st of January 2025.
31st January 2025.
He was paid 20% of his provident fund belatedly. 80%.
What you are claiming? 80% PF.
80% of provident fund along with interest on the entire provident fund and leave salary also they have not paid. And interest on gratuity.
Interest on PF and gratuity.
Lordship. And
what about leave salary? You are
leave salary not paid.
Till date.
Till date. And 80%.
You have not received leave salary for a period of 180 days.
Not 180 days. I have not paid the
anything towards leave salary.
Lordship.
So you are also seeking payment of leave salary.
Leave salary along with 80% provident fund.
Yes.
That's stupid.
Yes. Why leave salary has not been paid?
Lordship, if direct lordship, so lordship, we can clear.
Then he is also entitled to get interest on leave salary due to delayed payment. Till date, it has not been paid. You are for the state.
I'm for
State fund provide natural.
20% was paid in time.
No, belatedly.
That was within a month.
Gratuity paid.
Gratuity paid. That too belatedly.
Lord, he retired from.
Just a minute. Now, provident 80% provident fund and leave salary to be paid by 6 weeks, and interest on provident fund, leave salary, and gratuity
Paid within 3 months.
3 months. With a default clause.
Lordship.
Disposed of. তো দেখে নিও কারেকশনস গুলো, বেশ কিছু কারেকশনস আছে, অন্যভাবে করা হবে, পিরিয়ডটা আলাদা।
Item number 21.
Also same.
Yes.
Same.
Previous matter.
Previous matter.
Retired on
Malo retired on 30th of September 2025.
first you are seeking 80% PF.
Along, yes, and leave salary.
Leave salary, second, third, interest on PF, leave salary, gratuity.
20% PF delayed to be paid.
শুভেন্দু, আগে যেটা করলে সেটাকে ধরেই করতে হবে, শুধু ডেট অফ রিটায়ারমেন্টটা 30th September 25, এইটা ধরে করলে হবে না, অনেকগুলো চেঞ্জেস আছে, ঠিক আগের ম্যাটারটা, বুঝলে, ওইটাকে ফলো করে এটা করবে। ডিসপোজড অফ 80% provident fund and leave salary by 6 weeks, and interest on provident fund, gratuity and leave salary by 3 months with default clause.
Item number 22.
But 22 here, my prayer is for regularization of service in Calcutta State Transport Corporation. Regularization of service. Your Lordship, I was appointed on compassionate ground, wide memo dated 5/7/2005. Lordship, I was appointed on compassionate ground. Now, CSTC had a notification of 29th of October 2009, regularization 276 contractual employees who were appointed on compassionate ground. And in those 276 list, my name appeared as serial number 255, Your Lordship. But I was not, I have not been regularized.
What happened to rest of 276?
Rest of they were regularized.
Is why
Lordship,
petitioner was
this matter, Lordship, I have no instruction, Lordship.
Take instruction.
Lordship, kindly give me at least 1 week, Lordship. So I can
issue. Affidavit of service filed on behalf here for the state. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, petitioner prays for regularization of service as petitioner was appointed on compassionate ground in 2005.
Yes.
Stop. According to the petitioner, in spite of recommendation was made for regularization by the concerned authority, till date petitioner's service has not been regularized. Stop. Next paragraph, learned advocate representing Calcutta State Transport Corporation has prayed for accommodation to obtain instructions. Stop. State respondents are also represented by learned advocate. State respondents are also represented by learned additional government pleader. Stop. Next paragraph. A hearing of this matter stands urgent to enable the learned advocate for Calcutta State Transport Corporation to obtain instructions. List the matter under the same heading for further consideration on 16th February 2026.
Item number 23.
Thank you. It's 23, Your Lordship. I'm paying for the petition. Your Lordship, here I am paying for 80% of my provident fund along with interest.
Retired on
31st of August 2025.
PS.
I'm
What you are paying 80% per PS.
with interest on the entire provident fund and interest on gratuity and leave salary.
The interest on inter-retired.
Inter-retired. Your Lordship, this is this correct order, Your Lordship.
Interest on PF.
Gratuity, leave salary.
Leave salary and gratuity paid.
No, she belatedly.
State. Disposed of.
Item number 24.
May it please the court, I'm back to appear on behalf of the petitioner, my lord.
Yes.
I'm praying for not this week, my lord.
Why?
An appeal has been preferred for a similar issue before the division bench is pending. Kindly allow not this week.
Appeal whether against any order passed in this writ petition, appeal has been preferred.
No. The judgment that has been relied upon regarding that.
Maybe appeal has been preferred against any of my judgment, but why I will not hear this matter?
No. My lord can hear the matter. Not that. And my lord has a specific opinion on the issue.
Against that order, perhaps
I don't
appeal
know
has
what
been
he is
preferred.
saying, my lord. I don't have no knowledge.
Simply not today. Tell who is appearing.
Since 24th of December, they are taking time.
Knowing the view of this court.
Yes, absolutely. They are avoiding this court. Malad, this is the order passed in WP 28705 of 2025.
Where is your senior?
Is
You are not appearing in this matter.
she is in a different court. She is taking up.
He'll have to appear on Monday. Issue, record an order.
Grateful.
At the time of call, accommodation is paid for on behalf of the petitioner. However, Union of India is represented by a learned advocate. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on _21st January 2026.
Miss, I kindly record one line, Malad. Similar order was passed in item.
I remember. You pointed out on last occasion. You need not remind me.
Even Malad, prior to Times of India, Indian Express first published the news. Then
The removal of tattoo and tattoo scar.
yes. Even
My
if
lord,
that report is with me of the Indian Express. Malad, this is Indian Express and the report was published first. First we noticed, then the Times of India published. The latter,
Because, perhaps against that judgment order.
maybe, but that doesn't
But
prejudice
that I will
here.
not defer the hearing. Because I will pass similar order.
Absolutely.
Each agreed party may test
my lord, I shall satisfy your lordship on the next week, my lord.
Yes. Please come on the next date instead of seeking time.
My lord, kindly fix us next week, my lord. This week I have some difficulty. I'll be
Call
in
the next
Jolpaiguri.
matter.
Item number 25.
25, I'm paying for the petition.
For CSTC lead ones.
Lordship, here, I retired from service. Lordship, I retired from service on 31st of January 2025.
31st January.
2025. Lordship, I am paying for 80% of my provident fund and interest on the total terminal death benefits.
80% provident fund.
Lordship, and interest on delayed payment of entire provident fund. Entire
And
terminal benefits, I'm sorry.
Gratuity and
PF gratuity leave salary.
Yes, sir. Lordship.
January 2025.
Yes.
Who is appearing for the state? Disposed of.
Item number 26.
Lordship. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26. 26.
Yes,
Retired on 28th of February 2025.
28 February.
2025.
Yes, your
Paid
claim.
for 50% of my provident fund and interest on the delayed payment of entire terminal benefits. Gratuity leave salary and provident fund.
State is not represented. State is not represented. No drug bill. Disposed of.
Item number 27.
Item number 27, I am paying for only interest on gratuity.
I am for state respondents. So, no representation is made, my lord.
My lord,
3 months, 24 days delay.
my lord, I retired from service on 30th of April 2023.
30th
April
2023.
2023. Only interest.
gratuity was paid belatedly.
Lordship.
3 months, 24 days, my lord.
Yes.
3 months, 24 days.
Yes. What you are submitting? I couldn't follow. 3 months, 24. 3 months, 24 days. What?
Delay to give the gratuity.
So does it? Yeah, whether it does not make the petitioner entitled to claim
No, that I'm not
interest on gratuity?
No, that I'm not submitting. I'm submitting. No representation has been made to the authority.
30th April 2023.
Lordship.
24th August, my lord.
Please wait. Please keep quiet. If I require, I will ask you. শোনো, এটা না শুধু ইন্টারেস্ট অন গ্র্যাচুইট, সেই জন্য না কারেকশনস আছে বেশ কিছু, একটু দেখে নিন। ডিসপোজড অফ।
Item number 28.
Here I have a different prayer, Your Lordship.
Yes.
Here, I retired from service on 30th of April 2023 from Calcutta State Transport Corporation.
30th April 23.
23, Your Lordship. Now, Your Lordship, the payslip for the month of May 2023 shows that I have an earned leave in my credit as 17 days. So while releasing my terminal benefits, Your Lordship, Provident Fund has been paid by the order of this Honorable High Court, Your Lordship. Gratuity has been paid in time, Lordship, but the leave salary has not been paid. So I inquired from the corporation that what about my leave salary? Because I have a credit of 17 days earned leave. They said that you have an excess payment, so we have recovered it from your leave salary. But no formal order has been passed for recovery, or no notice has been served before my retirement or after my retirement that we have.
So your leave salary was adjusted against excess payment.
But this cannot be done, Your Lordship. How can it be done? Because no formal order was given to me, no order and nothing information was given to me prior recovering this amount. Lordship, the amount comes to 31,114.
Which was payable towards leave salary.
Leave salary.
That was not paid. It was adjusted. On finding that there was an excess payment, according to the
Lordship, according to the corporation, but no formal order, no information has been served before recovery, that it has been adjusted with that. And the second thing is that the area increment as well as the DNS allowance was also not paid. So in this writ petition,
area increment and DNS
allowance was not paid during my service period. What I'm entitled to, other employees have got. So my prayer before Your Lordship in this writ petition is that 31,114 towards my leave salary and the increment and DNS allowance, which comes to total of 48,000. So I'm praying for this 48,000.
So why you did not pray for increment during your tenure?
Lordship, today I have not received any instruction.
Why you have not asked for payment of increment during your tenure? Because that is in connection with your service which you rendered in the corporation.
Lordship, that was not made. It is admitted. I don't made any
And you retired in 2023, coming in 2026.
Yes.
And increment was not paid to me. What prevented you to claim increment at the material point of time?
Lordship, I have approached them verbally, but Your Lordship, I did not made any representation. Admitted. I'm candid before Your Lordship. That is the thing, Your Lordship, and this leave salary. So, and one more indulgence, Your Lordship. So liberty may be given to correct there's a typography, because I have made an amendment that there's a 62 days leave. So that should be 17 days.
Then you have to file a supplementary evidence.
Lordship, I will. Because the payslip says earned leave in my credit is 17 days. But Lordship.
62 days leave?
62, it will not be 62 days leave. It will be, instead of 62, it will be 17.
So may you file a supplementary evidence?
I will file it.
You take instruction in the meantime. Learned advocate, affidavit of service filed on behalf of the petitioner is taken on record stop. Learned advocate for the petitioner prays for leave to file a supplementary affidavit. As in the writ petition, period to be reckoned for payment of earned leave is wrongly stated 62 days.
Lordship, in paragraph 6 of the writ petition, page 3, paragraph 6.
Is wrongly stated as 62 days.
Lordship.
Stop. According to the petitioner, it should be 17 days instead of 62 days. Next paragraph. Let supplementary affidavit be filed by 10 days. Stop. Learned advocate representing
Calcutta State Transport Corporation.
Corporation has prayed for, is directed to obtain instruction. Stop. List the matter under the same heading for further consideration on 16th February 2024. Next.
Item number 29.
For the petition item.
Yes.
For the petition, I applied for the post of the Constable GD in Central Armed Police Force CAPFS examination 2025.
24.
25. My lord, at the stage of the DME, detailed medical examination on 19 November 2025, you are referred to the RME, review medical examination. And that was done on 21st to November 2025.
Where is review medical examination report?
My lord, kindly see the page 25.
Due to post, what is written?
Post
Tempo.
Tempenoplasty, graphic mild discharge in RTE. Let me submit one.
Just a minute. Penoplasty. Penoplasty.
পরে আবার কুড়িয়ে এসছে।
The problem in the ear.
Yes.
Tympanoplasty graphics. The repair of perforated eardrum. Now, whether under the revised medical guidelines, this is one of the ground for declaring a candidate unfit.
But I have not received instruction, only it is been told to me
You'll
that.
file a report. Petition, affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces. Stop. Petitioner was medically examined in review by Review Medical Examination Board on 21st November 2025 and was declared unfit on the ground of tympanoplasty graphics Stop. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared unfit based on revised guidelines by fortnight from date. Stop. List the matter under the same heading for further consideration on 16th February 2026.
Get close.
Item number 30.
Yes.
The petitioner, your lordship, applied in the year 2023 initially and thereafter 2024 before the NIT Durgapur for being appointed as a assistant professor. Thereafter, in the year 2023, the list he was not listed, shortlisted, and subsequently
He was
not shortlisted.
When participated in the interview?
No, there was no call. In the criteria, as per the benchmark, I was not listed. In the year 2023. In the year 2024, subsequently, based on the advertisement which I have annexed before your lordship, I also applied. But the result is not yet published as of now. In the meantime, there is an allegation leveled against the director of the Durgapur NIT, where the representative will show that how illegally the things are going on, and a bribe has been asked from the student only, this petitioner, by the director himself.
Where in you have found the report in newspaper?
No, advertisement, which is circulated in the
No, how the illegalities are being committed?
But I went
Where
there,
from you have heard it?
but I went there in the institute. I was also a student of the
So
institute.
you participated, you offered candidature in 2024, but it was not, the result was not disclosed to you.
As of now, till date, it has not been
Is
published.
there any provision for disclosure of result
It
or
has not
publication of
been
result?
made also. The result is not yet out. Publishing is a different issue. It is not out. The result of
If result is not published, then how you are affected?
well, I am not being shortlisted also as of now. But the most interesting thing is that the director himself has asked him that you pay me a bribe, otherwise I will not list your name. Allegation has been leveled. These have not been considered, despite making a comprehensive representation before the concerned authorities. Till date, that has not been considered also, my lord.
Show me the notification based on which you offered your candidature.
Kindly comes to page number 37. From there to 43, that is the advertisement and the form fill up which I have made. 30.
This is your letter, page 37.
No, 30, my lord. 23, my lord. The advertisement starts from there. Thereafter, the form is also there, which I have submitted.
Center. Allegation গুলো খুব করতে একটা ইন্টারনাল এনকোয়ারি চাই করতে হবে নাহলে এমএচআরডি কে দেবো কি
For which post you applied?
Assistant professor,
Grade 2.
grade 2 on contract, pay level 10, that is entry pay rupees 70,900 as per the advertisement dated.
Now, after making application, no communication, whether you are shortlisted or not, nothing.
No, it doesn't. It was not done to me. I inquired in the institute. Therefore, I got to know that various other people who are not in comparison with me and are below graded have been shortlisted.
Whether the selection is complete.
Shortlisting is done. Interview is not on. Has not been done yet.
No, my lord.
Are you representing NEET?
I'm NIT Durgapur registered. Respondent number 3. Thing is this: there are a lot of allegation made against the chair. That is a premier institute. What we require is an internal inquiry, and I will come up with the internal
What is
inquiry.
the present status of the selection process?
That is yet to be published, not yet been done, finalized, not finalized. Result is yet to be published.
No, shortlisting is complete.
Shortlisting, my lord, I'll have to ask for the instruction, total instruction, because I'm in a hurry. I was otherwise busy. My personal inconvenience was there. Contact করতে পারি না, কালকেই এসছি।
Issue. File your affidavit of service.
Yes, madam.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the petitioner offered candidature for the post of assistant professor grade 3 within bracket on contract.
Grade 2.
Grade 2, right? Grade 2 within bracket on contract in National Institute of Technology, Durgapur. Stop. It is alleged that due to malpractices, petitioner is not being shortlisted. Next paragraph. Learned advocate representing NIT Durgapur has prayed for accommodation to obtain instruction in order to apprise this court on present status of the selection process, which was initiated pursuant to recruitment notification dated 30th March 2024. Stop. Union of India is also represented by learned advocate. Next paragraph. List the matter under the same heading for further consideration on 28 February 2020, on 28 January 2026, in order to enable the learned advocate for 28 January 2026.
20 January.
In order to enable the learned advocate for the for NIT Durgapur to obtain instruction. Stop. On the next date, 28. Court is on the next date. Learned advocate for NIT Durgapur is required to apprise this court on present status of the aforesaid selection process.
Grateful, my lord. Grateful.
28th January. 28 January.
Yes. Okay, my lord. Grateful.
I see.
Item number 31.
Item number 31, my lord, Mr. Devashish Kundu is appearing for the petitioner, my lord. He's on legs, yes.
Yes.
He's on legs, my lord.
Who?
Devashish Kundu. Well, he is
At the time of call, accommodation is paid for on behalf of the petitioner. However, Union of India is represented. Union of India. However, Union of India is represented by learned advocate. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 9th February 2025.
Till 41, my lord, similar orders, my
Let the matters be called on one panel.
Item number 32.
No, these are with DME and perhaps, my lord, I'm not sure. 32, my lord, similar play.
Yes, 32.
Similar prayer, my lord. My lord,
You are appearing for the Union of India. Same order. 9th February.
Item number 33.
similar prayer.
Where is Mr. Kundu?
He's on legs, my lord. He has reformed me, my lord. On phone, my lord.
Medical unfit matter, my lord.
Yes, you are in item number 33. You are appearing for Union of India. Same order.
Item number 34.
Thirty-nine of these.
Yes.
Same as I am for the.
In all the matters, you are appearing for Union of India.
39 he is perhaps applied. 39 okay.
Up to 39.
Why generally different advocates are engaged by Union of India? Why? Because issue is same in identical in same. Are you aware of? Same order. Call one after another.
Item number 35.
Same order, 9th February.
Item number 36.
Same order, 9th February. ডাকো ডাকো শেষ করে দাও এই
Item number 37.
Same order, 9th February.
Item number 38.
এটা 16th February করে দেবে।
Item number 39.
Yeah, for the Union of India. 16th February.
Item number 40.
Sixteenth February, say
No,
nobody is representing Union of India, not today.
not today. 40 and 40.
You are appearing in this matter
My lord,
with Mr. Kundu.
my lord, I am his junior.
Yes,
Yeah,
that is,
well,
but
we
you are
sit in the
there.
same bar.
তাহলে record an out. আগের matter or file to দাও। File your affidavit of service.
My lord, I don't have any brief, nothing.
At the time of call, accommodation is paid for on behalf of the petitioner on the ground of learned advocate. Stop. However, Union of India is not represented to stop. Next paragraph, learned advocate for the petitioner is directed to serve notice upon the learned advocate representing Union of India by January 20th, 2026. Stop. List the matter under the same heading for further consideration on 16th February 2026. Next. হয়ে গেছে তো? Up to 41.
Item number 41.
Yes, who appears for Union of India?
No one is appearing. Human.
ঠিক আগেরটার মতো করে দেবে। Serve notice 16th February. Call matters from combined list. Yes.
So we appear for this.
Item number 47 for monthly list.
My lord, Mr. Supradim Dhar is appearing in this matter, my lord. He's on his way, my lord. I'm praying for a short passover, my lord. Just 5 minutes pass.
Not today.
Lordship asked me to produce the document, I am having.
Not today.
Today, not today. My counsels are suggesting not this week. Because tomorrow, second half.
Tomorrow there is a difficulty.
So that's why we are trying to make not this week so that he will be mentally.
Sir, not this week. Not this week.
I'm obliged.
Come back next Monday. Yes. Call the next matter.
Item number 50.
Forty-seven থেকে ডাকলো তো। আজকে তো 47 instruction. নিহারের যে ইনস্ট্রাকশনটা ছিল সেটা কোথায়? না না কোনো অসুবিধা।
Yes. Date of 7th pay commission recommendation.
Yes. Lordship.
Number one, just kindly, but just for 1 minute. And another one is about the production incentive, which is also paid, but on the basis of the old pay, not on the basis of the revised pay. That difference will I also pay.
Lordship, so far as 7th pay commission is concerned, that is government notified on 29 July 2016. And it was made effective from 1/1/2016. But Lordship, we are central government CPU, central government public sector unit. So sometime we adopt, sometime we modify, because we are a separate identity under Companies Act. So Lordship, we notified the same, adopting the 7th pay commission, close to it, on 4/5/2017.
Please tell me the dates.
Lordship, the 7th pay commission by central government notified on 29 July 2016. And such was made effective to him, effective to the central government employees, pure central government employees, on 1/1/2016.
29 July 2016 is a date of notification.
Sure.
And
With a
with effect
retrospective
from 1/1/16.
Lordship. We adopted the 7th pay commission on 4th of May. We means SIPL, means the Mint, which is now a company under Government of India.
4th May
2017. And same was made effective by an office memorandum dated 29 July 2016 from 1/1/2017. Means 1 year
later.
Yes, ma'am.
So petitioner is claiming benefit
under the central.
At par with central government.
Yes. We were central government. We were pure central government, like Ordnance Factory, Mint. These were a pure central government. But now, by notification, the Ordnance Factory and this has become a company under the central government.
Now, if it is adopted with effect from 1st of January 2017, then where is the
I'm
scope?
only interested. Interest, but I am only claiming that my prayer is only with respect to the interest because it was paid in August 2024. That's why, Lord, I am only praying for interest.
Only interest?
Only interest. Nothing differential amount of like that. Since it was
from which date this benefit, just a minute, overtime allowance.
Yes.
Overtime allowance was paid to you from which date?
Not paid with effect from 2017 as my certificate contains.
But it was paid to
in
you
August
in August
27,
2020.
That's why, Lord, I am praying for.
Yes, Mr. Banerjee.
If your lordship kindly see, probably his writ petition was claiming at par with the central government date. He is calculating.
There is no prayer for interest.
The representation is not for interest only. That is been
Have you prayed for interest in your writ petition?
If you kindly see, and if it is only for the interest on an amount, writ petition may not lie, lordship.
Interest.
Because then this is
the interest in the prayer itself.
accounting dispute, lordship, in that.
On overtime allowance.
Overtime allowance, whether overtime
Interest on overtime allowance.
overtime allowance is
payable to me in 2017, paid in August 2020. So for all these years, the interest is brought.
Allowance for 7 years.
no, lordship, probably.
And it comes to my representation, Lord, just for once. That's at page 26 representation.
No, but if yes, prayer is made for interest. Prayer is interest is also prayed for.
No.
So petitioner's prayer for grant of service benefits like interest on overtime allowance.
No,
For
request
7 years.
Interest on the area.
Now the thing is this: if court proceeds on the premise that it was adopted with effect from 1/1/71, 1st of January 17, instead of 1st of January 16, but the payment of
adopted is on May, but with retrospective effect.
Effective from 1st of January 2017.
Yes.
And it was paid in August 2024. Then why petitioner will not get interest? Tell me. It was payable from 1st of January 2017, not 16.
Lordship, then we have to see that after it is being adopted, it is implemented by us quite a late. Lordship can always say what is fallen from your lordship is absolutely correct and this. Lordship, I cannot justify a wrong. But the thing is, it has been adopted and implemented in a latter date. Lordship, this is policy. We cannot go into that.
No, but according to your adoption of the recommendation of 7th Pay Commission, it is payable from 1st of January 2017.
First, we make it effective.
It is payable from 1st of January 2017.
Payable. Then we will make payment start. It's not like that. Today I accepted it. Area we have given and immediately we are paying. It's not like that. Accepting and implementing, there is a gap. In every government company, there will be a gap because budget sanctionary things has to be looked in. And it was a phase, lordship can.
So if it is adopted on 4th May 2017,
but this is
at least from 5th May 2017.
No, he is returning. No. He is returning on 2024. He was returning.
Yes, but overtime allowance was paid as not as a part of return benefit.
Lordship,
then question would have been different. If you submit that overtime allowance is not a part of retirement benefit.
Whatever admissible
it was payable during the tenure of the petitioner.
Overtime, what was admissible at that point of time, we have given. Now, since it has been
difference amount, the difference,
lordship, let's take it.
Difference accrued due to adoption of
Yes,
seventh pay
yes,
commission
I understood.
recommendation with effect from 1st of January 2016. Now I accept your contention that though it was made effective from 1st of January 2017, but adoption was on 4th of May 2017 with retrospective effect from 1st of January 2017.
So let's
therefore adoption, one thing is indisputable that adoption was on 4th of May 2017. So after the adoption, when this overtime allowance was paid to the petitioner, that should have been the revised benefit should have been with effect from 1/1/2017, but it was paid in reality, it was paid in August 2024. So in that event, at least from the date following the date of adoption, petitioner is entitled to get interest.
But there is another gap. Lordship, I'm not justifying whatever Lordship will say, we will do it. But Lordship, what happens? Suppose, say, take the month of February 2017. February 2017, he was within this. So when it was actually February 2017, I paid him in the old rate.
Yes.
Then
that was revised after adoption on 4th May 2017.
So revised.
Yes.
So then suppose I paid him 10 rupees. Now after revision, he is becoming 12 rupees. So Lordship is saying why 2 rupees should not be paid with interest. That was precisely boils down to this. 2 rupees with interest because difference. 2
rupees with interest is to be paid from the date of adoption, from the date following the date of adoption.
True. Now Lordship, what happens? We adopt, we do it. Now Lordship, whatever the accrual thing he has, that we take it. And then when the implementation comes, first we adopt. Then we implement, adopt and implement, there is a difference because budgetary allocation comes into play. So Lordship, when there is a budgetary allocation, because we are government, we will not even if I pay 10 rupees less, my CAG audit will hold. So Lordship, budgetary allowance has come, then Lordship, we started allotting everyone. That was we have done. Now Lordship will see it is right or wrong. Now it is
differential amount. The
interest on the differential
amount, the interest on differential amount is required to be paid from 5th of May 2017.
Yes.
After the date of adoption.
But adoption.
Not from 1st of January 2017.
That means, moment we say 5th, that means adopt and implementation is same. But in government, adoption and implementation, it again goes back to the board. Then the budgetary allocation comes from the finance because my 100% share is with Government of India. Then my finance allocation comes.
But enhanced benefit you paid in August 2024.
Yes, that's it. So
are you in a position to explain the delay up to August?
So Lordship,
cannot be.
Lordship,
you are not in a position. Court knows.
Lordship, yes, Lordship. Why I will beseech your Lordship. He has made a representation. Lordship.
No consideration of representation. Considered and rejected for interest. We know the outcome of this consideration of representation.
আসলে আমার তো নয়, আমার হলে তোমায় দিতে পারতাম।
But another thing is that another segment to that incentive allowance, that is also paid on the basis of the old pay. So that is to be revised. Not that I have given a chart. That is also to be revised in terms of the recommendation. That is what kindly see this page 15. It's a calculation. It's a 35% of the basic pay. But their difference comes, I am entitled to get this 46,000 also. Not kindly see just from one. 50,000 is the basic pay current after revision. Then it comes about
production incentive allowance.
It is also permissible.
It has not been paid.
No, it has been paid on the basis.
What is your instruction on this? What is claiming with regard to production incentive allowance? What is your claim?
Now, my case is that production incentive allowance has been paid, but the calculation is based on the old pay, pre-revised.
To that extent, you make a representation.
That is, I've given.
Quantification is, according to you, is wrong.
No, they have.
Then you make an appropriate.
I have made.
Court will not quantify.
No, I'm not saying that quantify.
Yes.
I have made the prayer in the representation. That has not.
Yes, Mr. Banerjee, I will direct that you make the payment on differential amount, pay interest on differential amount
and decide
from 5th of May 2017 till the date of payment at the appropriate rate. And so far, quantification of production incentive allowance.
Beside that,
Let a representation be made and that will be considered by the appropriate authority in accordance with.
Yes, Lord.
Petitioner was an employee of Security Printing and Minting Corporation of India Limited. Security Printing and Minting Corporation of India Limited, who retired on superannuation on 1st September 20. Who retired on superannuation on 1st September or 31st of August?
1st September 2020.
On 1st September 2023. Stop. Grievance of the petitioner is twofold. Hyphen. Delayed payment overtime allowance as per 7th Pay Commission recommendation. And release of production incentive allowance not at appropriate rate. Stop. Petitioner prays for interest on overtime, revised overtime allowance due to delayed payment and payment of production incentive allowance at revised rate. Next paragraph, blind advocate representing respondents has submitted Seventh Pay Commission recommendation was adopted by Security Printing and Minting Corporation of Security Printing here referred to as corporation by the corporation on 4th May 2017 with effect from 1st January 2017. Stop. According to corporation, as 7th Pay Commission recommendation was made effective with retrospective effect based on its adoption on 4th May 2017. Petitioner may not be entitled to get interest on revised overtime allowance. Stop. From the submissions, next paragraph, from the submissions made on behalf of the parties, it appears that corporation adopted 7th Pay Commission recommendation on 4th May 2017 with effect from 1st January 2017. As a result whereof, petitioner was entitled to receive revised benefit under overtime allowance with effect from 1st January 2017. Stop. As date of adoption so far corporation is concerned is 4th May 2017. Delay caused in releasing benefit, revised benefit up to 4th of May 2017 is not attributable to said corporation. However, petitioner is entitled to receive interest on revised benefits towards overtime allowance, allowance as per 7th Pay Commission recommendation from 5th May 2017. Being the date following the date of adoption, that is 4th May 2017. Next paragraph. Hence, concerned authority of Security Printing and Minting Corporation of India is directed to pay interest at the rate of 6% per annum on revised benefits towards overtime allowance, as per 7th Pay Commission recommendation by from 5th May 2017 till date of payment by 8 weeks from the date of communication of this order. Next paragraph. Petitioner shall also be at leave to make a representation for appropriate quantification of production incentive allowance by fortnight from date. Who is the appropriate authority?
Respond number two, General Manager.
Page 26. Before the General Manager of corporation, being respondent number 2, stop. If such representation is made within the aforesaid time, respondent number 2 shall decide the same in accordance with law by 10 weeks thereafter on passing reasoned order, and same shall be communicated to the petitioner by fortnight thereafter. Next paragraph, writ petition stands disposed of.
Just one indulgence, wherever your lordship observe the pay commission is a central pay commission. 7th Central Pay. 7th Central Pay Commission.
Or subject 7th Central Pay Commission. Next.
Item number 65.
Appear for the respondent.
65, I beg to appear on.
In this matter, your lordship will see there is no scope for interim order. So we like to file my affidavit in opposition.
Termination, no subsistence allowance, nothing of this sort.
Yes.
Termination, and 6.5 years old, I have done my duty. And
Petitioner was working where?
my lord, this is a organization which
Lab
is my lord, the
cost,
government undertaking.
Water resource.
Union of India undertaking.
So termination order has been passed against the petitioner.
Yes, my lord, against.
Where is that order?
I'm sure. Lordship will find from the page 24. 11/6/2025.
Two. There was full-fledged disciplinary proceeding.
No.
Then
Terminated, my lord.
Contractual employee lordship documents have not been annexed at all. He's
Lordship,
seeking only regularization.
Kindly see, my lord, page 15.
6.5 years only work, seeking regularization, contractual employee, most documents they have not annexed.
15 may kindly
We'll
be
bring
looked
all the documents on.
where is your appointment letter?
Kindly see page 15.
Mr. Chakravarti, where is your
15,
appointment?
my lord, page 15, annexure P1.
15.
Yes, my lord. They themselves declared my date of superannuation is 29/2/2048. Lordship will find, my lord, 19/9/2018, my date of appointment. Then, my lord, the middle portion, lordship will see date of retirement in the year 48.
Where is your appointment letter? I am interested to see your appointment.
This is, my lord.
That has not been annexed.
How you are inducted? Let me see.
Lordship.
How you are inducted?
Contractual.
Your lordship will see
Only
page,
the appointment letter.
your lordship page
Admittedly
17 if
contractual.
your lordship sees.
Kindly see, my
Appointment
lord,
letter.
No, it's not appointment letter.
page
It says
17, lordship will
this is
find,
to
my lord.
certify that Suraj
On
Khan
contract
is on
consolidated.
consolidated basis.
Page 17.
From
My lord,
19.
I'm not hiding anything, my lord.
Contract
Page 17.
letter is not.
basis is posted at the project office, Kolkata.
Even then, my lord, contractual, my lord, full-fledged inquiry is required to be made, my lord. In this fashion, fire and fire, my lord.
So I will bring all those documents on record, what has been done.
If you are appointed on contract consolidated contract, if you are a contractual appointee, what is your right?
No, but at the same time, they themselves indicated my date of retirement is 29/2/2040.
Show me your appointment letter, Mr. Chakravarti.
Yes, my lord, as my learned friend is praying, my lord, let there be exchange of affidavit.
No, show me your appointment letter. Why I will be direct
I am not
exchange of
disputing, I
affidavit?
am a contractual. Page 17. I am not.
If you are a contractual, if court proceeds on the premise that you are a contractual employee,
my lord.
where is your right to get the benefit of
Well,
principle
my
of
lord,
natural
kindly
justice?
see, my lord, in the event, even a contractual employee, my lord, termination in this fashion is, my lord, whether, my lord, there are. Well,
that's why I want to see the appointment letter.
I may be allowed.
He will get. We may get the indication with regard to notice period and other things.
I am not disputing. I am a contractual. I am a
Regularization
contractual
as a
one.
permanent employee.
Six
That
and
is
a
what his prayer is.
6.5
in regularization.
half year I am working. And suddenly, my lord, taking leave and all this, my lord, they have terminated my
Kindly see prayer A. Reinstate the petition's previous post with continuity of service.
Leaves on.
It's prayer as if he's a permanent employee who has been illegally terminated.
My lord,
I need
kindly
to know
see
interim
B,
order has also been prayed for.
similarly situated contractual employee. My lord, equal with the equal, not with the unequal. B, my lord. Applicable norms as per on per.
You show what the appointment letter says. That has not been made a part of the writ petition.
Sure. Leave is granted to the petitioner to file a supplementary affidavit disclosing disclosing his appointment letter. Stop. Let such supplementary affidavit be filed by 10 days from this. Stop. List the writ petition under the same heading in the combined monthly list of February 2020.
Let a copy be served
2026.
up. You should let a copy of the supplementary.
You will get a copy. You need not be worried.
Great.
Item number 66.
Please, your lordship, my lord. I am appearing on behalf of the petitioner.
Yeah,
My lord, this matter was taken on 13th of November 2025.
just a minute. Instruction.
Lordship, the petition has been filed by aggrieved by and Lordship that notification dated 15 January 2024 and the Lordship Departmental Promotional Committee held on 29 December 2023. Lordship, that subsequently two promotional departmental committee has been constituted and it was found that he is physically unfit, Lordship. So, Lordship, the cause of action has been subsequently, Lordship, that it's a.
Then why the one post was kept reserved?
Lordship, that is in respect to the.
Come to page 23.
Yes, Lordship, may I submit? Lordship, that is in respect to the vacancy.
Just a minute. Why petitioner's promotion was deferred?
Lordship.
In 2023.
Lordship may kindly appreciate that that has been, Lordship, reserved for the purpose of reconsideration. As subsequently it is found that he is, Lordship, physically unfit. For the reason, Lordship, that low medical category, Lordship. And that reservation.
File a report.
Lordship, that vacancy was in respect to the year, Lordship, 2024. Subsequently, two reservation year was on the in force, Lordship, 2025 and 2026 as well, Lordship. In the two medical consecutive two medical committee, Lordship, he has been found unfit. And reservation was in respect to the vacancy of the 2023 only, Lordship. Subsequently, that there is two other.
It appears that there was a consideration of petitioner's representation.
Yes.
Petitioner's promotion.
Yes.
Also considered and DPC held at MH on 29 November, December 2020.
29 December 2020.
Case of the petitioner after going through all relevant records. Accordingly, one vacancy of DIG has been kept reserved for him.
Yes, Lordship.
Now, why his case was deferred? Case of promotion was deferred.
Because that we need to that the department want to consider his case fresh, Lordship.
May I submit? Petitioner was appointed as an assistant commandant, having been qualified in the UPSC examination. He was not marked as poor medical category. While he was serving the duty in the year of 1995, while he was returning from the duty, he sustained injury. There is a procedure. Court of inquiry was conducted for assessment whether this particular the sustaining injury can be attributable to the bona fide government duty or not. There is a procedure. My learned friend is not aware of the fact. This the court of inquiry held that this injury is a bona fide government duty. That has been done pursuant to the approval given by the by the Director General of Border Security Force, which is evident from page 15. Then, my stand was assistant commandant. I have been promoted to DC, deputy commandant. I have been promoted to second in command. I have been promoted to the commandant. Now, my next promotion, when other candidature has been considered, my candidature has not been considered. Rather, there is a policy paralysis. Kindly have a look at page 16. The relevant portion. The competent authority has also accepted the recommendation of the DPC made in the meeting held on 29th of December 2023 for deferring the case of the such and such of the commandant such and such Accordingly, one vacancy of the DIG,
Page 23,
page 16.
16.
Page 16, relevant portion 17.
Competent authority has accepted the recommendations.
And the meeting held on such and such, deferring the case of the such and such, such and such. Accordingly, one vacancy of the DIG has been kept reserved. That means when the my lord, the recommendation has been made, it was within their knowledge that my lord, he is entitled to, but certain consideration has remaining left to be considered. That's why the vacancy has been left vacant. Subsequently, my lord, they have to furnish before this court that what is the policy. For my lord, A, one policy would be followed. For B, other policy would be followed. It is not that. There is a standing operating procedure. As to why I have been promoted, although I have been earmarked poor medical category, having been qualified and approved by the DGBSF, because 3 promotion has already been given to me. In that
Even after sustaining injury.
Yeah, even after sustaining injury, and it has been held that I am, my lord, the bona fide government duty. Kindly have a look at, my lord, page 15. Whereas the CY, Court of Inquiry, was ordered by the 54 BNBSF, video order number such and such dated 21st of October 1998, to inquire into the circumstances under which see such and such, 54 Battalion BSF, now such and such, met with an accident on the 14th of December 1995 near such and such camp, Jammu, while returning from leave. Whereas the Court of Inquiry proceeding, relevant document and the remarks of the officer commandant, 54 BNBSF of the Court of Inquiry has been examined in detail in this headquarter. The inquiry sustained by such and such, the then 54 BNBSF, now DC, that means already promoted, DC 145 BNBSF, is attributed to the government duty. This has the approval of the DGBSF. So, my lord, bona fide government duty. So I should not be punished. My lord,
by denying promotion.
By denying promotion. Although, my lord, this injury has been sustained during the course of my active duty, and that has been approved by the DGBSF.
Show me the policy relating to promotion.
My lord, I don't.
That even if after sustaining injury, which is attributed to bona fide government duty,
so, my lord, one second, my lord,
injured officer is entitled to get promotion.
My lord, 3 occasions I have been promoted. 3 occasions, and
that's why they are submitting that physically you are not fit.
No. It is not the physically fit.
Or physical deficiencies are there.
Yes. Poor medical category is considered on the basis of the medical examination of the medical directorate. So, my lord, 2 aspects are required to be considered. When I would be earmarked as a poor medical category, certain other administrative duties has been given to me. That's why the commandant is a rank of the senior superintendent of police. That has been given to me. It is not the singular promotion that by mistake that has been given to me. DC, second in command, and the commandant. I am going to, my lord, the retired on 27th. The decision has been kept pending since 2023.
27?
2027. So no reason has been assigned since 2023. So if that be the so, as to why the no reason has been given, this is not the fair act on their part. Ought to have been stated that you are not entitled to, this is my policy. Policy does not permit you to get.
That has been communicated to him, lordship. That
then if it is so, then how petitioner was thrice promoted to higher rank?
Lordship, that is lordship.
Because, sustaining injury is
yes,
the
lordship,
reason
2 promotion has been
not
given to him.
Not
That is
finding the petitioner physically fit for being promoted to the rank of now.
He is a commandant.
Deputy Inspector General.
Yes, lordship.
DIG. Now, then after sustaining injury, how petitioner was promoted thrice?
Lordship, that I need to, lordship. I'm carrying this, lordship, that instruction from the department, lordship. If lordship may kindly see this.
Yes, whether the court will find answer.
That has not been explained, lordship. That has not been explained. That for the what is the policy providing that the due to the after
to produce their standing operating procedure.
Lordship, that if your lordship may kindly allow, that lordship may kindly allow, then for 2 weeks, lordship, we shall that lordship seek instruction. It is submitted by the department that lordship after the 2023 there has been 2 other departmental promotional committee
which found lordship, found him that lordship he is physically unfit. Lordship will find from the
Physically unfit is a
paragraph
different
3,
word,
lordship.
It has not been stated anyway.
No, lordship, that has been communicated to him that he is physically unfit, lordship, for the post. That has been communicated to him, lordship.
Matter relates to promotion of petitioner from the post of Commandant Border Security Force to Deputy Inspector General. Stop. Submitted on instruction by the learned advocate representing Union of India that petitioner was not found physically fit for being promoted to the post of Deputy Inspector General. Stop. Next paragraph. On the contrary, Mr. Shubhobrata Datta, learned advocate representing the petitioner, has drawn attention of this court to an order dated 13th August 2008 of Deputy Inspector General, wherefrom it appears that petitioner met with an accident on 14 December 1995 and sustained injury. Stop. According to the concerned authority of BSF, such injury is attributable to bona fide government duty. Stop. It is further submitted that in consideration of this aspect, subsequently petitioner was thrice promoted to the next higher rank. Stop. According to the petitioner, at the time of his promotion to Deputy Inspector General, injuries sustained by the petitioner due to accident ought not to be a ground. Stop. Next paragraph. Question arises for consideration when petitioner was on 3 occasions promoted to next higher rank after sustaining injury. Why his right to be promoted as Deputy Inspector General to be denied. Next paragraph. Concerned authority of BSF is directed to file a report disclosing the reason for not promoting the petitioner till date based on promotional policy. Stop. Let such report be filed by fortnight from date. Stop. Hearing list the matter under the same heading in the monthly combined list of February 2026.
Only one correction. This is the order of the Director General of BSF, which has been signed on behalf of him.
Which page 15?
Page 15. This is an order of DG BSF on behalf of DG BSF. He is the staff officer,
But it's a Deputy Inspector General personnel.
Inspector General signed it on behalf of the Director General. It is an order of Director.
আচ্ছা ওখানে দেখো তো 13th August 2008 অর্ডারটা যেটা বলেছি। না, issued on behalf of it is Director General BSF.
DG BSF.
On behalf of DG BSF. এইটাই করে দেবো, সাইন টাইন গুলো দরকার নেই।
May I take back that?
Yes, take it back.
Item number 67.
Here, my lord, the question is, my lord, it's interpretation of a legal provision.
Yes.
Interpretation of a legal provision. Now, an application was invited for the post of, my lord, Deputy Harbour Master, River and Port, my lord, under the Kolkata Port Trust, now known as, my lord, Shama Prasad Mukherjee Port, Kolkata. Now, I being the petitioner, my lord, there are twofold experiences, my lord, that are required. First is, my lord, experience for more than 7 years. And second is, my lord, the master's FG certificate or dredge master grade 1 certificate, my lord. Now, I applied duly. I was kept in the dark. Subsequently, it transpired that the private respondent, whom we have served already, now he has been appointed by changing the rules of the game after the game has commenced.
Show me service upon the private respondent.
Yes. Well, may I file the affidavit of service? Affidavit of service is on record, my lord.
No, affidavit of service. Yes.
My lord, page 6. Item has been delivered on 3/7/2025.
You have to serve it again due to change of determination, Mr. Bhattacharya.
ওরা appear করেছে কেউ? তাহলে বলছে change হয়েছিল determination. No, but what I was humbly suggesting, but after filing of the writ petition, the Port Trust has responded to the demand for justice that we made, which I introduced by way of a supplementary affidavit.
Without hearing respondent or private respondent, I will not pass any final order.
But we'll serve in the meantime, my lord, if they can come up with any report, my lord.
What report? What report?
Report indicating their stand, because they have indicated their stand in the response only to the demand for justice that we made, my lord. So it is already on record. This is a matter which can be also disposed of on the next day once the private respondent appears.
Yes. Or at least service is complete.
Service is complete.
Service is complete because but that service is in connection with filing of the writ petition before a coordinate bench.
That is definitely there, my lord. But I am placing the supplementary affidavit on record, my lord.
File it.
And I'll serve another intimation, my lord. Indicating
Because
the next day.
respondent number 7 is the selected person.
He is selected. He is already officiating, my lord, in the post. With
Now, if your writ petition is allowed, then the
No, I am not saying that, my lord, allows my writ petition today itself.
No.
I say that I'll come back.
I'm just trying to make you understand that what is the importance of serving the respondent number 7.
Absolutely. But I am not that unreasonable, my lord, that I'll be making that prayer, my lord. What I was humbly beseeching, my lord, is, my lord, I'll come back. Let them also come back with the report.
Yes, Mr. Mojumdar obtain instruction.
Both have to be, not probably all the respondents have to be heard. We can file our affidavit. He is also required
It's
to be
not a
heard.
case, but a question of filing of affidavits. The
No,
stand is clear, my lord.
That's his estimation.
No, they have
The
already.
court's estimation may be different.
After serving the respondent number 7, let the matter be considered on the next issue. In spite of service of notice, apart from respondent 7, all other respondents are court represented.
Yes.
In spite of service of notice, respondent 7 is not represented. Next paragraph, learned advocate for the petitioner is directed to serve notice upon respondent number 7, enclosing copy of this order by 10 days from date and file further affidavit of service on the next date. Next paragraph, list the matter under the same heading in the monthly combined list of February 2026.
Returnable date.
Yes.
A returnable date, my lord.
From the combined list, I am not fixing any matter on a particular date.
I can mention
Come
and travel, my lord.
Yes.
But let them come back with a report, my lord, with instructions. my lord.
Next paragraph. Port authorities are represented by Mr. Mojumdar, learned senior advocate. Stop. Learned advocate for the port authorities is directed to obtain instructions.
My lord.
Instruction.
Extremely grateful to your lordship.
Item number 68.
My lord, I am appearing on behalf of the petitioner.
Lordship, I appear on behalf of respondent.
Yes.
My lord, retired employees of my lord, Bridge and Group Company.
Retired employees of?
Bridge and Group Company, my lord.
On appeal is pending.
Yes, your lordship, there are two appeals.
My order.
Against your lordship's order, but another division bench has passed the order. My lord, your lordship knows just.
Mr. Somo Mojumdar appear on behalf of Vision Group.
Yes.
So far I remember in the original side, and I passed an order against that appeal is pending.
Yes, Your
the
Lordship. There are
coordinate bench
two
has
appeals pending before the Honorable Division Bench, Your Lordship.
Another division bench has already passed the order. Justice Boshak's division bench has passed the order. They have filed the review application and cross appeal that has been rejected. I've annexed all these things. And so far the other division bench is concerned, the matter is pending. Your Lordship, kindly come to the first, Your Lordship, come to page 17.
Court fees?
Court fees has been.
It appears that is in respect of one petitioner, court fee has been paid. There are 3 petitioners. And why the retirees are coming jointly in one petition? Because their date of retirement is different. Dates of retirement are different.
Because,
and you are claiming the benefit of probably interest and other benefits.
Yes, those who are retired.
Other retired benefits.
Because common cause of action, because those retired between the 1st January 2017 and 31st March 2018, they are entitled to give the benefit of the notification, all are retired between the 1st January 2017 in between and 31st March 2018.
An application.
Yes, yes, there are two appeals pending before the Division.
Yes, court fees paid.
Yes. Page 17, you will come to page 17. There is a notification issued by the Public Enterprise Limited. The payment of gratuity under DPA guidelines is subject to affordability of CPS concern effective for the period from 1st January 2017 till 28 March 2017 in respect of executive and non-unionized supervisor of CPS on IDA pattern where the pay has been revised with effect from 1st January 2017. Now, Your Lordship, kindly come to page 56. Order passed by the learned coordinate bench.
No, in one matter,
Yes.
I passed an order.
Yes. Your Lordship,
Where
passed
bridge
on
and
the-
roof was
appeal.
responded.
But
That is in the original side. Then a contempt application was filed. In contempt application, when the contempt application was taken up for consideration, then Mr. Partho Sengupta, learned senior advocate, appeared on behalf of the bridge and roof, alleged contender, and submitted before this court that the appeal was preferred, and the Honorable Division Bench is in session of this appeal.
Yes, that's
So the
right.
hearing of contempt was adjourned. So I want to know that what is the outcome of that appeal.
That appeal is pending, my lord. There is no stay order till now. And so
But that is touching upon the same issue.
same issue, but other division bench has passed the order, my lord. Therefore, it is also binding upon your lordships. Justice Boshak's division bench.
No,
has
but I
declared-
still
Lordship, we have filed a review against Justice Boshak's order.
I still remember that at the time of hearing contempt petition, it was pointed out that an undertaking was given before the Honorable Division Bench that not to press the contempt
that
application.
other council.
Yes. So ascertain and come back whether ascertain
appeal
that what
has
is
been
the what is the outcome of, or what is
appeal has
what is the result of that
That
appeal.
appeal has been fixed by the Honorable Division bench on 22nd
21st of January, Your Lordship.
22nd January, my lord.
Come back. Let me see. Issue. Matter is heard in presence of the learned advocates representing the petitioner and respondents and respondents Corona and Bridge and Roof Company within bracket Bridge and Roof Company within bracket India close bracket Limited. Union of India. Union of India is also represented by learned advocates. Stop. Next paragraph. From the submissions made on behalf of the parties, it appears that one intra-court appeal touching upon similar issue is pending before the Honorable Division Bench. It is before before the Honorable Acting Chief Justice.
No, before the division bench presided over by my Lord Justice Muthunesh Prasad.
কি বলছিলাম? Before the Honorable Division. Stop. Hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration in the monthly combined list of February 2026.
Item number 70.
My lord, item 70, Mr. Shishona Bandyopadhyay appearing for KMDA, my lord. My lord, he's on his leg, my lord.
For the state respondents.
My lord, difficulty is that if it is possible for, I'm praying for days adjournment, if possible.
Mr. Mojumdar.
I believe KMDA has lent its force as of today. I had a talk with Mr. Abhishek Guha. He has sent the proposal to the government. Okay.
My lord, proposal has been
There was a question of persons being deprived in promotion. So persons who were technical assistants, they were sent on deputation. The juniors came back and got promoted. So not after a long run litigation, not we were found to be eligible for promotion in line with those persons who got promoted in the meantime. So ultimately, up to the Honorable Supreme Court, we succeeded. Now, not please come to only 2 pages. This will probably permit your lordships. I mean, your lordships may be swayed to dispose of the writ petition on these 2 documents, page 75 and 89. The government decided that the pay of those promotees should not be disturbed.
Where petitioners are working.
KMDA. The persons who were found to be illegally superseding us, their pay would not be recovered. So the government decided to protect them. So as a natural corollary, it was also decided that our pay should be stepped up if their pay was to be protected. Please come to page 75. And they have found my client to be eligible for that.
Page 75.
Yes. Now this is government writing to KMDA. Anomalies of fixation of pay for engineers or officers of KMDA who were sent on deputation in different urban local bodies under Kolkata Urban Services for the Poor KIU SP. I am directed to refer to the above subject and to inform you the following as per observations of the Finance Department, so and so. The promotion of engineers on deputation to the ULBs to the post of assistant engineer allowed in the parent office of KMDA on repatriation is not admissible under the extant rules and orders of the government. So, one set of officers were found to be wrongly promoted. However, in compliance with the judgment of Honorable High Court dated 5th March 2012, such promotion of deputationist engineers in the post of assistant engineer in KMDA from the date that is 1 to 2005 on which they went on deputation may be considered as a fait accompli in this distant date. In view of acceptance of point number 2 above, there is no need of refixation of their pay by obtaining fresh option under ROPA 2009 in the post of technical assistant, senior assistant engineer in KMDA. So, their pay was decided not to be disturbed, those persons' pay. However, after allowing promotion of deputationist engineers to the post of executive engineer from the post of assistant engineer in KMDA on the basis of common gradation list of technical assistant, later redesignated as junior engineer, sub-assistant engineer, if any senior to the deputationist engineer as per the gradation list is drawing lesser pay in the post of executive engineer, such disparity in pay may be removed by allowing stepping up of pay subject to approval of the Finance Department.
So you are seeking this stepping up?
Yes, this stepping up. And the government directed KMDA to do this. Now please come to page 88.
Just a minute.
details.
So at present, petitioners are working as executive engineer.
And I have superannuated in the meantime as executive engineer.
When?
I superannuated in 2020.
Two petitioners.
2020.
So why you are coming today?
Not the government decision.
July
Is of,
2025 writ petition?
the government decision is of 2024. Please come to page 88.
Page 88.
Compliance to the orders of the court. I am directed to state that compliance to the orders of the Honorable Court and subsequent MAT cases, etc., have been duly considered in this department as per observation of the Honorable
Where
Court.
is that order?
The Honorable High Court's order. That's at page 28. At page 56. There's the operative portion.
KMD has to initiate the process of stepping up.
on calculation. Not
So
paragraph.
what is the stand of the KMD needs to be considered.
Yes, so not they have to send it once again to the government.
But page 88, under paragraph 3B,
Yes.
after ratification of the said list, the authority in KMDA will initiate the process of stepping up.
Of pay of those petitioners and similarly.
So what is the
circumstanced-
stand of the KMDA that needs to be considered?
But that's why I had a talk with Mr. Guho. He said that he has sent the list to the government.
You are appealing for the state respondents. What is the stand of the KMD needs to be considered
has sent the
with
list.
regard to, because clause 3 says the writ petitioners, the respondents in the appeal, if allowed to suffer retrospectivity.
That is those persons whose promotion was found to be flawed. So their government decided that there should not be no retrospective adverse affectation of rights. So no downgradation for them. So consequently, those persons who actually suffered, that is our clients, their pay should be stepped up. And this calculation should be made by KMDA. And please come to paragraph B at page 88. After ratification of the said list, the authority in KMDA will initiate the process of stepping up of pay of those petitioners and similarly circumstanced staff as
Now, whether that is applicable in case of retired employees, retired executive engineers.
I retired in 2020 and 21.
Yes.
That's it.
Prior to that, what steps you have taken for stepping up?
There's a decision taken in 24.
So yes, 2024, then.
So all those persons who had been found
when
to be
the orders were passed by the Honorable Court.
In 2010, 2014, the SLP got dismissed.
So that is the basis of taking such decision as it emanates from page 88.
Yes, please come
so
to page.
Then if that is the position that these orders were passed in prior to your retirement, then you ought to have taken steps prior to your retirement.
Please come to page 88 once again.
Yes, I am on page 88.
Now, in order to process the said matter, in order to process the said matter in a judicious way, that's implementation of the court's order. The following steps are required to be taken from your end towards proper appreciation of the issue. To identify the petitioners and similarly circumstanced staff, but I was a petitioner, who were senior to those 19 deputationists as on 1/2/2005. The gradation list containing names of such staff is to be ratified by this department. So, as on 1/2/2005, the gradation list has to be checked up. After ratification of the said list, the authority in KMDA will initiate the process of stepping up of pay of those petitioners and similarly circumstanced staff. As per direction of this department in due course, the financial implication with regard to such stepping up of pay with arrears may be simultaneously worked out by KMDA. A format for execution of the aforesaid exercise is enclosed. I was a writ petitioner.
Whether you are similarly circumstanced staff.
I was a writ petitioner, as referred to in this clause.
The petitioners. Whether this ratification has not been done by the department.
Mr. Guhu had told me yesterday
My
that he
lord,
had sent this to the government.
My lord, so far as the later dated 3rd October 24.
So the two steps are required to be taken in terms of 4th March 20, page 88. First ratification, and after ratification of the said list, the authority will initiate the process of stepping on. Now, whether the ratification has been.
My lord, came so far as the later dated 3rd October 24 is concerned. My lord, may I kindly peruse this document, my lord. KMDA has provided the list to the Additional Secretary Government of West Bengal for consideration of pay scale of who claims to be the higher pay scale in respect of the after superannuation, and petitioner names was there which is appearing in list, and it is subject to the consideration of Finance Department, who will consider ultimately.
Now, whether the ratification as indicated in page 88 has been done. That is what I want, because the methodology which is required to be followed is that to identify the petitioners, and similarly as Mr. Majumdar is submitting the petitioners, both the petitioners are the petitioners in the previous writ petition.
Yes, yes. It has
Now, to identify the petitioners as similarly circumstanced staff who are senior to those 19 deputationists as on 1st of February 2005. The gradation list containing names of such staff is to be ratified by this department. Whether these steps have been taken.
This has been taken, my lord. Revised is containing the name of the civil and circumstances officer and the deputies at the point of time they was represented to KMDA, and list was prepared by the KMDA considering this aspect, and it was sent to the additional secretary for consideration.
Do you have any instruction?
No, my lord, I have not.
My lord, kindly peruse this. It will definitely. Kindly come to the page 14, my lord. Name of the petitioners 1 and 2.
Really file a report in terms of this, whether the steps which you have taken in terms of this memo dated 4th March 2024.
My lord, kindly peruse the once come to page 75, my lord, kindly. It is the expressly written in this memorandum that.
Yes, page 75.
However, after allowing the promotion of department engineer in the post of executive engineer to the post of assistant engineer in KMD on the basis of common gradation list of technical assistants as regarded as a junior engineer and sub-assistant engineer, if any senior to the deputy list as per the gradation list is drawing lesser pay in the post of executive engineer, sir, disparity in the may be removed by allowing stepping of the pay subject to the approval of Finance Department. So far as our party is concerned, we have prepared the list, we have considered, and we have sent to the state government for consideration. And this is the last communication which is made to the on our part.
So this stepping up is subject to the approval of the
Finance Department. So for our party is concerned, we have done.
So we will disclose it by file a report. Disclose it. That you have stepped up, but that requires a note of the Finance Department. I was under the impression that the petitioners are merely retired employees, but they are not part of the.
They are petitioners who succeeded in challenging the promotion of the deputationists who were granted promotional post on deputation.
So you retired as executive engineer.
In 21, petitioner number 1 in 21, second petitioner in 2020.
Petitioner, both the petitioners are claiming taping up of pay by the concerned respondent authorities. And in this regard, steps which are required to be taken are spelled out in a letter dated, in a communication dated 4th March 2024, issued by Additional Secretary to the Government of West Bengal, to the Chief Executive Officer, Kolkata Metropolitan Development Authority. Stop. Next paragraph. It is submitted on behalf of Kolkata Metropolitan Development Authority with within bracket for short KMDA. তারপরে next paragraph এসো, it is submitted on behalf of KMDA. The steps as per letter dated 4th March 2024 have already been taken on behalf of KMDA, and issue is pending before the concerned state authorities for approval. For approval. Stop. Next paragraph. Concerned authority of KMDA is directed to file a report in the form of affidavit disclosing the steps taken to step up pay of the petitioners by 10 days from date. Stop. Learned advocate representing state respondents is directed to obtain instruction whether any decision is taken by the state authority after the exercise completed by the concerned authority of KMDA in terms of said communication dated 4th March 2024 or not. Next paragraph, list the matter under the same heading for further consideration in the monthly combined list of February 2026. উপরে দিয়ে দাও। হ্যাঁ communication rule. Your instruction is crucial because they have taken steps according to them for stepping up pay. Yes, call the next matter.
Item number 71.
My lord, I beg to appear in virtual mode, my lord, today. I am appearing for the state, my lord.
Yes, username and password.
Yes, I have got.
Where you have disclosed that you have obtained username and password. Which, yes. Just a minute. Have you served copy upon the learn?
Right now, my copy of the supplementary affidavit, my lord.
Yes.
Just now he has served, my lord.
Very well, you go through it because now he's made a statement in paragraph 3 that petitioner could not. You rightly pointed out that when the last occasion matter was heard,
My
there
lord,
was
give me 2 days. I will
password.
come with
There
the
was no, there was no username password at the time when matter was last heard on 13 November 2025, but it is disclosed candidly in the supplementary affidavit that due to health ground, petitioner could not visit the employment exchange officer immediately thereafter. On 29 November 2025, petitioner got enrolled in the employment with the employment bank, and username and password has been provided. So if username and password is provided as it appears from annexure P1 to the supplementary affidavit, then why petitioner will not get the benefit under Jubo Utsaho Prokolpo?
My lord, subject to your correction, my lord, allow me to take the instruction from the concerned authority, my lord.
Supplementary affidavit is filed today on behalf of the petitioner, which was affirmed on 1st December 2025, and same is taken on record. Next paragraph. Now, it's taken on next paragraph. Copy of the supplementary affidavit is made over to the learned advocate representing state respondents. Next paragraph. Mr. Sahi, learned additional government pleader, appears on virtual mode and has prayed for accommodation to obtain instruction. In order to apprise this court whether benefits under Jubo Utsaho Prokolpo within bracket YUP close bracket hyphen 2013 can be extended to the petitioner or not. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration in the monthly combined list of February 2025.